Good morning, ladies and gentlemen. Good morning, colleagues. Welcome to the Supervision Conference jointly organized by the European Data Protection Supervisor, the European Agency for Criminal Justice Cooperation, and the European Public Prosecutor's Office. Could I just ask you to switch your mobile phones off, or put it at least in flight mode? And since we have a hybrid conference today, for those who are following us on the live stream, the panels have the possibilities to answer to your questions in the WebEx chat, please. So let's begin. Regrettably, Mrs. Vera Jourova, the Vice President of the European Commission, will not be joining us today because of other urgent commitments. But without further ado, it's my pleasure to give the floor to the European Data Protection Supervisor, Mr. Wojciech Wieworowski.
Thank you very much. I'm happy that you managed to get into the building, which is not the easy thing in Center Borchette. And we can start with this slight delay. Thank you for presence today. Thank you for coming to this conference. The conference, which is one of the highlights of this year for EDPS. You know that we organized one enforcement conference in June this year. So the question might be, why do we need some other conference organized by EDPS? But actually, if we think about the supervisory tasks of EDPS, that's probably the most important part of our tasks at the moment. These areas where we take the supervision, where we have already some experience, when we can summarize that and look ahead. So we think that the Law Enforcement Directive on one hand and EPPO, Eurojust, EU DPR regulation, and other data protection and criminal justice, they met the data protection and criminal justice got married. And that, what historically was not very closely linked as the field of law, is now coexisting very closely, impacting one another. This process calls for attention, for careful observation and scrutiny. It is an opportunity to evaluate the impact of these laws. Do they work? Do they make sense? Are those tasks with the implementation and enforcement are delivering? Is it bringing tangible results for the people, for the citizens? It has been 3 years now since EDPS is supervising Eurojust. EPPO is fully operational now as well. And data protection authorities in member states are starting to work closely together to coordinate their supervision activities in these fields. I think it's a perfect moment for the first summaries, first lessons learned, first new homeworks for us, and sometimes when you have the conference like that and you have the organizer speaking at the beginning, he is delivering the conclusions already. So this is not my task. That's what I will try to avoid. I avoid presenting my conclusions before the debate starts. I would rather share more personal reflections, just 3 reflections at the beginning. The first one, and quite obvious one, although not always obvious for all the people in the room, we usually do not take it in our minds, is that criminal justice and law enforcement are not the same area. They work closely together. There is no one without the other, but they should be looked independently. We all know very well the historical similarities and differences. Justice on one hand and home affairs are even structurally divided in the European Commission, although often they work together. From the data protection perspective, judicial dimension of the criminal justice area does make a difference. Compared to traditional area of law enforcement, understood as the field where the police authorities are operating. And these differences have direct impact to the supervisory tasks that we held. The involvement of the prosecutors and especially courts occur in principle only after law enforcement authorities. The data is on average more reliable, more filtered, has undergone some scrutiny, and applicable procedural regime is on. On one hand, it could mean that the Data Protection Authority could be more relaxed, but it also means, given the state the criminal proceedings, that the sensitivity and the vulnerability may be brought to individuals, and the extra attention is necessary. We will hear later today about specific operations conducted in this field. My second reflection for the beginning of the day is a bit similar, and its paradoxical nature is very well visible. That criminal justice is the field which is governed by very good lawyers. Magistrates, prosecutors, judges, attorneys, they are all qualified, they all have a long experience, usually years of experience and education. And you could think it means that the respect for law, the level of compliance is naturally higher, that there is less risk of infringement of fundamental rights, that the system in itself aims at achieving fairness. And so from a data protection perspective, things should be fine. But again, it is true, but with this comes another possible trap. The thing with good lawyers is that they have their views. And if they don't, they are very good in proving that somebody else is wrong. So it means that the Data Protection Authority needs really do the best to maintain the status of authority. I'm proud of EDPS team for ability to engage in this field. I myself have no doubts in their expertise, but it did not have to be the case in the interaction between EDPS, EPPO, Eurojust. They are done in the spirit of mutual respect to the expertise of one another. It's not always the case that the EDPS in its supervisory practice is experienced in the field. But we try to make the best possible team with the best experience coming also from the national level. For the EDPS, it's quite new area, but for data protection, these are already years of expertise. And the third reflections. One thing without which neither data protection authorities nor courts or prosecutors or offices can operate. One that sadly we all need to still fight for is an independence. Independence of judicial authorities, independence of data protection authorities, which is the key foundation for the rule of law. Data protection entered the criminal justice and is there to stay. EDPS is here to stay as well. Supervision in the field of criminal justice reinforces EDPS' position as fully-fledged data protection authority. It also bridges the distances between fields for many reasons. The specific regime for EPPO and for Eurojust that somehow is a patchwork of the systems from the Chapter 9 are something that will be debated today. But irrespectively to the development of this debate and the potential legislative changes in the years to come, I would like to stress that EDPS is committed to ensure the coherent application of the laws leading to the strong respect of fundamental rights to data protection, and being also the example for our friends on the national level. I wish we will have a fruitful debate, and I will try to stay with you throughout the whole day. Thank you.
Thank you very much, Wojciech, for this introduction. And indeed, I can confirm supervising EPPO and Eurojust is very demanding. But before we start the first session, let me welcome the president of Eurojust, Mr. Ladislav Hamran, who has kindly accepted to give the keynote speech to the first session, which is dedicated to Eurojust. Mr. Hamran, please, the floor is yours.
Thank you so much, and good morning to you all. First of all, I would like to thank Wojciech for bringing us together and actually devoting a conference to Eurojust and to EPPO in general, to justice and to data protection arrangements in this field. Attending a meeting via video conference is rather symbolic in these times. However, I have to also say that this was not my intention initially. So I wanted to be there with you. However, some urgent operational needs require my presence here. But I'm still grateful that you accepted and allowed me to participate via video conference. I have to, as a scene setter, I would like to say that in last 20 years, we are observing a real revolution in area of criminal justice. 20 years, Eurojust was established, and while there were still question marks, what would be the purpose, what would be the added value, today, I think no one questions the importance, the added value, and the purpose of our existence. I have to say that in 2002, and the year when Eurojust was established, we were dealing with a few cases. And actually, after 20 years of our existence, we have supported in 2021 more than 10,000 cases. And already for the first 10 months of this year, it's clear that we already surpassed 10,000 cases from 2021. And most probably we will even surpass the 11,000 cases. So this is also showing the huge development and also trust from the member states, from our partners within the EU and outside. And also it shows the huge progress and evolution in this area. Obviously, our numbers are reflected also in the technology in data protection arrangements. And we, in 2015-16, were taking an internal look how actually we work with data, how data is being exchanged with our partners within the EU, outside of the EU. And we came to a conclusion that we have to significantly modernize our case management system and our also digital tool which we use. In December 2017, Eurojust presented its vision to ministers of justice in Brussels. We presented a paper which is called Digital Criminal Justice. And already in 2017, we as practitioners, we were pleading for secure communication channels between judicial authorities. We were pleading for cloud-based evidence storage places. We were also pleading for technology which allows exchange and safe, secure transmission of large files, digital files. We were pleading for secure video conferencing solutions and for counterterrorism register and many more tools which would allow us to be in the 21st century and work in a digital environment more securely. We do hope, perhaps a little bit selfishly, but we do hope that this paper inspired our partners in the European Commission, and the European Commission translated this vision into legislative proposals to move criminal justice cooperation online. And as we speak, actually, the Joint Investigation Teams collaboration platform, which is a cloud-based, secure online storage, evidence storage place, or the counterterrorism register, are taking the very final shape. And this is a fundamental change to how we conduct our business. And the digitalization agenda goes even wider to also include a new generation of our case management system. We hope that very soon we will have a state-of-art case management system, which will also move Eurojust into 21st century in order to store operational data in relation to cases we support, but we also will be able to implement the link detection and the hit-no-hit connections with the databases of Europol and the European Public Prosecutor Office, for which we are ready and expect the pilot projects to start early in 2023. So all this demonstrates that digital channels will become the default mandatory ones for all judicial cooperation, communication and data exchange between competent national authorities. This will ensure a much smoother exchange of information and evidence between EU member states, but we are to continue offering support and coordination. The information flow needs to be ensured also to and from the central level, which in this case is Eurojust. The recent armed conflict in Ukraine also brought up new challenges. We are currently facing a rather complex and fragmented operational landscape. We are aware of 21 parallel investigations in member states, in 4 other European countries, US, Canada, and we also record an impartial and independent investigation by our partners in European Criminal Court. So this obviously calls for coordination. And today, if you would ask a very simple question, who has collected what and which evidence concerning the armed conflict is available where, in which countries, which witnesses or victims were heard, in which countries, how much videos, photographs, or satellite images, or 3D scans of area are collected, we don't know. So in order to coordinate all these investigations, also to facilitate the smooth execution of letter of requests, to avoid duplication of investigations, to avoid over-victimization, or even to avoid over-documentation, Eurojust is now have a new mandate and also a very important new task for our partners in the EDPS, because we are now having a new mandate to set up a core international crime evidence database, which will allow Eurojust centrally store and analyze war crime evidence, including photographs, satellite images, videos, and audio recordings. This task goes hand in hand with many challenges. And I have to say here that our partnership with EDPS brings also in this regard a very fresh views and reassurance that we will meet the expectations in the member states, which are eager to send us their data, their evidence. So, dear colleagues, dear ladies and gentlemen, based on this, on the many elements I raised here, it's fair to say that the world of EU judicial cooperation is in flux. With the advent of new and digital cooperation channels and an ever-increasing workload. But the new Eurojust regulation, which entered into force in 2019, helped us prepare for this. Among many other things, if transferred oversight from the joint supervisory body to the EDPS, and in doing so, it was the start of a very productive partnership. For all these reasons, dear Wojtek, I would like to express my gratitude to you personally for being so approachable, honest, and credible partner. And also our gratitude goes to your whole team. So we enjoy the partnership, and we are looking forward to many years of fruitful and productive cooperation and partnership. Thank you so much.
Thank you very much, Mr. President, for this introduction, and I hope we will add to and develop on some of the elements you have delivered in your introduction speech. But before we go to that, I have to share something personal with you. When I was at high school, I was playing guitar, and I always had this dream of performing in front of a huge audience, like a national stadium. I guess this room and a couple of participants online, let's say, is as close to this dream as I get. But don't worry, I will not play, because it's not about me, it's about Eurojust today. And I'm happy to have with us people who know a lot about Eurojust. And let me start the introduction of our panelists with Mrs. Diana Alonso Blas, who's for many years has been the data protection officer and the head of data protection service at Eurojust. And she also worked for the Belgian and Dutch data protection authorities and the University of Leuven. So I'm very happy, Diana, to have you with us today. I also have Ms. Michaela Ritenauerova from the Czech Ministry of Justice, who is working for the International Department for Criminal Matters. But during the Czech presidency, she also is the chair of the Council Working Party for Judicial Cooperation in Criminal Matters. And our third guest is Anna von Harnier, policy advisor at the European Commission, DG Justice, and she's responsible for several legislative initiatives in the field of judicial cooperation and digitalization. She is seconded to the European Commission by the German Federal Ministry of Justice. My name is Michał Fila, and I am working for the EDPS. I'm responsible for supervision of EPPO and Eurojust. So before we go to the substance, just one announcement. If you have any questions on the presentations or the discussion that will follow, please note them down. We will have a question and answer session at the end of each session. And those of you who follow us online, you can ask them through the WebEx chat available. So we will try to answer them afterwards. But let us prepare the ground for discussion, and let us start with the first presentation that will bring us all on the same page when it comes to the recent developments at Eurojust. I would like to ask Anna von Harnier to introduce us to the legislative landscape, which is changing. Anna, the floor is yours, please.
Yes, thank you very much. And I would like to start with expressing our appreciation for this conference. We think, the Commission thinks that it is really important to bring the two communities, criminal justice and data protection, closer together and to strengthen the understanding for the concerns of each another. And indeed, I've been tasked to briefly present 3 recent proposals, which are closely linked to Eurojust's works. 2 of them are actually amendments of the Eurojust regulation. Go to the next slide, please. And that are the proposal on digital information exchange in terrorism cases, which relates to the counter-terrorism register, which Ladislav referred to before, and the proposal on preserving, analyzing, and storing evidence relating to international crimes at Eurojust, which is actually already adopted by now. And finally, I will also briefly present the proposal on the establishment of a joint investigation teams collaboration platform. These 3 proposals have common themes. They deal with exchange of information of evidence by competent authorities. They have a strong digitalization component, and they involve cooperation with third countries. Next slide, please. Coming to the proposal on digital information exchange in terrorism cases, which is part of the digitalization of justice package adopted by the Commission on 1st of December 2021. It aims to remedy some of the most pressing needs for digitalization at Eurojust, which are the improvement of the European Judicial Counterterrorism Register, the modernization of Eurojust's internal database, the case management system, and the establishment of secure digital communication channels between member states and Eurojust. And I'm happy that Ladislav already spoke a bit about the difficulties with the internal IT system and the communication channels. The European Judicial Counterterrorism Register, short CTR, was established at Eurojust in 2019 with the objective to better and earlier identify links between terrorism cases cross-border. This prototype has already enabled national authorities to identify cross-links, to secure arrest, and finally also convictions. However, the CTR currently does not identify as many links as it could and is very labor-intensive for the competent authorities and Eurojust. In addition, it involves a lot of manual transfers of operational data sets, for example, from the national databases, and also then at Eurojust to include it in the case management system. And that, of course, is prone to error and also not very data sensitive, taking also into account the confidentiality and sensitivity of this operational personal data. So the objectives of our proposal were to, first of all, create a clear legal basis for the counterterrorism register within the Eurojust regulation, which sets out clearly what kind of data should be sent by the national authorities to Eurojust for the purpose of this counterterrorism register. Secondly, to digitalize Eurojust's case management system and to establish secure digital communication channels between Eurojust and the national authorities. And finally, to clarify how data can be shared with third countries through the case management system. A short state of play, indeed, as Ladislav also mentioned. We are already now in trilogue discussions, but the general approach has been reached under the French Council presidency in June, and the European Parliament adopted its position in November. And well, maybe Michaela will say more about it, but the Czech Council presidency is still very ambitious with this proposal, and we are grateful for that as well. And we would also like to thank the EDPS for its constructive comments. And well, I mean, of course, we don't have a final agreement on the text yet, but looking at the negotiations, I think most, or maybe also all of the recommendations were taken on board. Next slide. Coming to Regulation 2022-838 on preserving, analyzing, and storing evidence relating to international crimes at Eurojust. Maybe for that, a bit of context is necessary. The Russian war of aggression on Ukraine had also a strong impact on the work at Eurojust. With the unique experience which Eurojust has in supporting investigations and prosecutions into international crimes in the member states based on universal jurisdiction, and also the cooperation agreement with Ukraine and with the secondment of a Ukrainian liaison prosecutor to Eurojust. Eurojust was in a perfect placement to actually support these investigations from the very beginning. And accordingly, Eurojust supported the quick establishment of a joint investigation team between Ukraine, Lithuania, and Poland, which was later joined by Latvia, Estonia, and Slovakia, and by now also Romania, and to which also the International Criminal Court participates. Thereby, Eurojust really became the coordination hub for the prosecution of international crimes in Ukraine. To strengthen this role, the Commission proposed urgently to amend Eurojust's mandate to allow Eurojust to preserve, analyze, and store evidence relating to international crimes. And I'm also happy that Ladislav elaborated a bit more in detail on that before. And in addition to this mandate, it was also necessary to actually allow Eurojust to temporarily store data outside of the case management system, of course, subject to data security and data protection because of the technical limitations of the current case management system, but also due to the sheer volume of data now. And here we would like to point out that it is crucial, a crucial step in the development of this new database is actually the consultation of the EDPS. And this amendment was adopted by the co-legislators in record time. It entered into force in 2022, and Eurojust is currently working on the implementation. I think Diana will say more about that later on. And I have to say one more time, I would like to express our gratitude to the EDPS for also adopting, well, its opinion on this proposal in also record time, because that only enabled the co-legislators to adopt the proposal as quickly as they did. Next slide, please. And finally, I would like to say a few words about the proposal on the establishment of a joint investigation team's collaboration platform. So what is actually a joint investigation team? It is a very useful and successful tool for the cooperation between national competent authorities in the investigation and prosecution of cross-border crime. It is established between the competent national authorities in specific cases, they conclude to do so. They conclude a JIT agreement to facilitate the exchange of information and evidence, and they define the details of cooperation in this agreement. Also, third countries can become JIT members, as well was seen also in the example of Ukrainian participation in the joint investigation team at Eurojust currently. While this may facilitate the legal framework for data exchange, in practice, the exchange remains quite cumbersome, and the lack of secure communication channels, it makes it often difficult because sometimes the competent authorities have the choice between using insecure channels to communicate quickly or not communicating at all. So this is what we aim to remedy with the establishment of a JIT collaboration platform. It should enable swift and secure digital exchange of information and evidence between the JIT members, and should also have additional tools, for example, secure chat functions. And also here, the Council reached a general approach in June, and the Parliament adopted its position in October. The first trilogue took place on 14th of November. And again, also the Czech presidency has high ambitions here. Next slide, please. And I would like to conclude with a few thoughts on Eurojust and data processing and data ownership, because I think it's important to highlight the general principles of judicial cooperation when it comes to data ownership, especially because the data ownership is actually with the national authorities, and that is also the common practice in this field. So these authorities can always decide what kind of information is shared with whom. And when we speak about data sharing with Eurojust, this actually does not mean that the data is shared with Eurojust as a whole, but a competent national authority always only shares its data with the national desk of the respective country, and only in a second step and in close consultation with the national authority, the national member of that specific country shares the information with that other national desk, with which the national authority seeks to cooperate. And the architecture of the current case management system, but surely also of the new case management system, which is supposed to be established under the CTR proposal, it reflects that, because so each member state has its own space with own access rights, and each case is stored separately, and the national member then decides who gets what kind of access on case-by-case basis. Actually, the same principles also apply to the Core International Crimes Evidence Database and the Joint Investigation Team's collaboration platform. In both cases, the data remains under the control of the national authorities, and they can decide with whom they want to share what kind of information. Thank you.
Thank you very much, Anna, for this overview from the Commission. And as we have heard, 2 of those proposals are being currently negotiated. And I think it's worth to hear from someone who is at the very heart of these negotiations. Michaela, you are the chair of the Copen Working Party, and that's where the member states discuss the proposals of the Commission. Could you tell us more about the position of the Council? And you also work for the Ministry of Justice for in the Czech Republic. So I'm wondering, you spent many years dealing with cooperation in criminal matters. Could you also perhaps share your views from the practitioner's perspective as well? Yes, please, the floor is yours.
Everybody, first of all, thank you very much, Michal, for invitation to this conference. I was very pleased. And thank you for this opportunity that I can present the opinion from the member states' point of view here, and also from the practitioners' points of view. Yes, indeed. At the moment, I am in the very center of the negotiations in the Council, because I'm representing the Council in both proposals that are on the table, which is the CTR regulation and also the JITS collaboration platform. And we are currently trying to reach the final stage in both of these proposals, which will shape the final text, and hopefully we will be able to finish this during the Czech presidency still. So I would like to follow up on what Anna has presented here and comment on each of the proposals, and also on the act which has also been adopted, which is the war crime regulation. I have taken part in the negotiations in all of these legislative acts, and also I have also taken part in the negotiations regarding all the acts basically which concern Eurojust since 2007. So my legislative memory is quite long in this respect. So I would first like to make some general remarks as regards the position or position of the member states or practitioners through the member states here as regards the data protection or data exchange with Eurojust. So generally, we have to first emphasize that we are dealing here with very special category of data. It concerns very sensitive data in live criminal cases, which are often concerning sensitive details that go way beyond information pertaining to an identification of a person, usually. So even the special categories of data upon which a person may potentially be discriminated. To that end, Eurojust, ever since its establishment, has a very strict and detailed system of data protection, very good rules and detailed rules on data ownership, and possibility of subsequent sharing of such data. Member states have always been aware of that. And the system of data protection or trust to the system in Eurojust has never been an issue during the negotiations of any act concerning Eurojust. Of course, it might also be because we are criminal experts, not the data protection experts, and in the end, maybe it's because nobody actually has really understood this section, which deals with the data protection. However, I think that due to that, the practitioners have in general very high trust in Eurojust from this point of view. And they are not afraid to share their data with Eurojust, which is very important. So as regards the individual acts we are talking about here, so firstly, the regulation or the proposal of regulation as regards the digital information exchange in terrorism cases. So, the proposal has been presented by the French presidency, which has reached a general approach in June. Currently, as I have mentioned, we are we are in the phase of negotiation with the European Parliament. And during the negotiations in the Council, the member states, what were the main concerns of the member states? The member states were mostly concerned of having sufficient discretion on when the obligation to send the data to Eurojust or to CTR, which is the counter-terrorism register, should start applying, as such data may be of very sensitive nature at an early stage of investigation. So not only from the data protection point of view, but it's rather in order not to jeopardize the investigation. It was very important to have in place the exceptions that would allow the member states to exercise this discretion in this sense. For example, exceptions not to send the data if it should anyhow jeopardize the investigation or if it concerns the protection of safety of an individual. Second major issue was on which data should actually be sent to Eurojust. In the annex to the proposal, there is a list of information which in my opinion also go quite beyond on what is usually necessary in order to sufficiently identify a person if we talk about, let's say, non-criminal case. However, the member states also have not really disputed any of these, so the list was quite widely accepted. The discussion was very diverse as regards the biometric data, because the proposal of the Commission originally included also the obligation to send the biometric data to Eurojust. And here the opinion of the member states really differed from seeing the added value in sufficiently identifying persons, especially from third states, in order to strike a balance what is necessary in such cases. And there I felt that the data protection rules were actually the driving force. We ended up, or actually might end up, because the negotiations are still not over yet, to actually have the possibility only to send the biometric data to Eurojust, because the opinion of the member states really differed from actually not to be obliged to send the information at all to be obliged. So we probably will end up with having the possibility to send the biometric data to Eurojust, should it be necessary in the opinion of the competent authority to sufficiently identify the person. Second major issue that was widely discussed, and which is maybe more interesting from the data protection point of view, was whether to process at Eurojust the data which pertained to a person who was acquitted in the criminal proceedings. So who has received, where the judgment has ended in acquittal, or the person is no longer prosecuted. Again, the member states' opinion varied from very strict no to quite a keen yes. Yes, such processing would have an added value in finding the potential links to criminal proceedings in the other member states, which is the objective of the counterterrorism register. While the person might be acquitted in one member state, the details of such case might help a criminal case in another member state, where such person would not be so lucky anymore. However, some member states could not get over the fact that such person was actually pronounced not guilty in such case, and therefore we shouldn't anymore store his or her data in relation to a criminal case, which only might be initiated, and maybe their data protection rules does not allow for such a situation anymore. This is a perfect example of where actually to strike the balance between a successful result of criminal proceedings and data protection rules or presumption of innocence. So this is quite we can have quite a nice academic debate on this. And finally, I would also like to point out that member states were very much welcome the new case management system and the security rules. Though I am not aware if there has ever been any case of misuse of data sent to Eurojust due to the insufficient security of the system. And I also think that it has not really been of concern to the competent authorities, I think. It is highly desirable that the system is well protected and up to date, especially due to the sensitivity of the data. Okay, I'm bothered with a fly here. Interested in sorry. So it is highly desirable that the system is well protected and up to date, especially due to the sensitivity of the data we are dealing with. So now I would like to go to the second proposal, which is on board, which is the JIT collaboration platform. Because it's also currently being negotiated, and we still don't have the final shape of this. So basically, the most key issue in this act is the fact that who can have access to the platform and under what conditions. In this regard, the most discussed articles were the ones which deal with such access. Member states required the clarification of the rules of access for each specific type of the platform user, which might be the member state, third state, but also an EU agency, and recently, most probably, also the international judicial authorities such as ICC. There's one interesting fact. Originally, the Commission proposed actually less strict rules for the access rights than the member states subsequently required. But again, the technical security is welcomed, and I believe that none of the competent authorities will have any issue with uploading their data. And thirdly, I would like to comment on the war crimes regulation, as Anna mentioned. So this one is a bit extraordinary. We are in a bit extraordinary situation. The regulation was adopted in a record time, extremely quickly. There was a limited time to consider the details of the act in depth, even though there has been some questions as regards what actually is meant, or what actually is meant by the analysis or preservation in practice. But the member states understood the seriousness and the need of the objective at the time of the negotiations. So there was no general concern that the data will be processed outside the case management system. Besides that, most of the operative changes actually concern the rules for processing data in this case. There was a common agreement on these rules. Nobody really disputed those. The safeguards seemed quite sufficient and well supervised. So this is an exception from the rule in a very extraordinary situation, which we all understand and which was widely accepted. So I think here the goal basically overrides the means. So this is to my comments on these proposals, and thank you.
Thank you very much, Michaela, for presenting this overview to us, and good luck in the negotiations with the Parliament and the Council. Well, when I look at these changes from the perspective of the EDPS, the fly is very persistent here. One thing is clear to me, but this will be a significant increase in the volume and type of personal data that is going to be processed at Eurojust. And when we visited Eurojust last year, I think, well, we saw that the case management system is not really fit to process all this data. And yeah, there is a serious practical challenge in front of Eurojust to accommodate these needs of the member states. Well, I'm wondering, Diana, how do you manage with this? Can you can you just give us an idea of what's going on at Eurojust in relation to those proposals? And yeah, then we will maybe also discuss in more detail the one that was already adopted and is already in force. So please.
Thank you very much. Yeah, you can start the presentation. Thank you. Well, maybe let me start by thanking again the EDPS for this opportunity, and also I would like to thank the fellow panelists today here, not only for the good work in preparing the conference, but also for the excellent cooperation in all the Eurojust work that is ongoing and the different initiatives that we are discussing today. Indeed, as Michal said, there are a lot of challenges for us. I will speak particularly about the implementation of the Core International Crimes Evidence Database, but of course we do have many other challenges we could be discussing. So maybe going straight to the beginning, as it was explained already by our President and by Anna as well, Eurojust has a central role in this discussion within the EU justice system, mainly because of its role in coordinating and ensuring the cooperation between the judicial authorities, but also because of the existence of the cooperation agreement we already had in place with Ukraine since June 2016. And we have had since August 2018 a Ukrainian liaison prosecutor in-house. So we did have very close and excellent working relationships with Ukraine. It's important to say that while this amendment to the Eurojust regulation brings this whole new area of work to Eurojust, it does not change the mandate of Eurojust. And I think this is important to clarify. So it's not that we would be receiving evidence unconnected with some kind of ongoing investigation or prosecution. What we are supposed to receive should be then linked to some kind of judicial procedure of investigation, which is at least open in one member state, or it could be in several member states. So it's not like some kind of unconnected evidence that could be parked there to be just preserved. Eurojust had indeed quite some experience also in this area because we are supporting the genocide network. So we do have already quite some experience in the area of genocide, crimes against humanity, war crimes, and related criminal offenses. And therefore, it was indeed decided to give this task to Eurojust. So I think our president already explained a little bit why this was necessary from the operational viewpoint, so I will not insist much on it, but it's clear that in this whole area of war crimes, it's very important that the evidence is brought together somehow, that is at this moment very fragmented and complex, is in many different countries, because also the refugees from Ukraine are moving for many good reasons, various countries. This fly is really extremely persistent. There was a story a few weeks ago in the press about Ukraine having some kind of mosquitoes with virus is circulating. I think this is a Russian fly, which is sent here to spy on us. So I hope it's taking notes as well. Anyway, the database we are putting in place will allow us to link the evidence that is being collected by the different authorities from the member states, and this would be provided to Eurojust on a voluntary basis. So it's not that they will be obliged to provide it to Eurojust, but they can provide it to us if they see an added value for us on receiving it. So, as it was already explained by Michaela and Anna as well, this proposal was adopted in a record time, and what was decided to do to facilitate the work of Eurojust was to allow us to process operational data outside the CMS for very practical reasons, because indeed our good old CMS has been there since 2004, and although we have been updating it many, many times, it's not up to the technical standard of dealing with this amount of information of this nature. However, let's say, I'm sure this was done with the best intention of facilitating our work. I'm not sure it did, to be completely honest, because while we have been for years working on designing our new CMS, as our president explained, with market research, with a lot of work on requirements, etc., we are supposed to do now the same exercise in a few months, creating a parallel system outside the CMS, but with the same data protection requirements. So, well, I will call it a challenge, to say it nicely, but it is really a very, very big challenge in order to have this in place. And I think we need to take into account that people feel very strongly about this. We should not forget the atrocities that are being committed in Ukraine by the Russians, and people feel very strongly about the need to help Ukraine here. However, I think if we really want to help the Ukrainian authorities, we need to do it by complying very strongly with all the data protection rules and human rights and applicable procedural laws, because otherwise this collection of data and evidence will not be helpful in the longer run. So there is, I would say, a especially high responsibility here in ensuring compliance with data protection rules, or at least I feel it this way. So in order to deal with this challenge, the approach we have chosen, given the time frame and the constraint we have, is to work in phases, little step by step, and also to rely on existing tools which were already used by different EU agencies with good results, and try to work in procedures around it. And I will show it in one of the slides. So if we move next, you can see we have tried to divide the process in different components. So there is a first part, which is the receipt of information and evidence, which is the part we are working on now. There is a second part, which is the processing, storing of this information. A third one, which is the data analysis of both structured and unstructured data. And then the last part, which is the feedback to the national authorities. And we are working on this on a step-by-step approach, really deploying the elements one by one. So maybe just to give some very few preliminary clarifications, because these are the questions we receive from all people. The first one is, what does it mean, evidence, in the context of this regulation? I'm not sure there is an unanimous answer to that, but what it is in any case clear is that we are talking about digital copies of evidence. We are not thinking about storing rockets or ballistic proofs or whatever at Eurojust, which I can tell you this question was asked at some point. We are really talking about digital copies of the evidence. How this will be transmitted to Eurojust, we are looking now on how to ensure, and I think this is from the data protection viewpoint, one of the key elements, how to ensure that the information we receive is properly labeled already as to the categories of persons from the national authorities, because according to the Eurojust regulation, it has to be decided by the national authorities what is the category of person whose data we are being processing in accordance with the national law. So we need to know if this person is a suspect, if he's a witness, if he's a victim. This has to be decided at national level. We are working on a legal form, and I mention it like it's a very simple thing, but I can tell you this is costing a lot of internal discussion. A form that will guarantee that every contribution we receive has certain boxes that the national authorities have to label, and they have to clearly indicate to us what is the category of this person. We don't want to have data which is there floating without knowing to which categories belong. We have to learn from experiences and mistakes of others, put it this way. So what we will have is evidence registration log, which contains what we call the metadata with no personal data, which will be initially shared within all the Eurojust national desk and licensed prosecutors, but the access to the real contributions, to the real evidence, will only be happening on a case-by-case basis, respecting indeed, as Anna mentioned, the ownership principle, so what have the national authorities indicated to us, and also the need to know. So initially, that's how it's going to be done. And let's say that in practice, if the real evidence is going to be used in court, then the usual instruments will need to be used, the mutual legal assistance and so forth. So this is not replacing the existing judicial tools in place. So going to the next slide, you will see there a beautiful picture of Wojtek and I before COVID. So when people used to go to the office every day and wear nice suits and everything. Let's say in this whole discussion, the cooperation with the EDPS is key. The Eurojust regulation amendment contains as a guarantee to ensure that data protection is properly put in place, the need to notify to the EDPS before we start the operation of this new automated data management and storage facility. And it says the DPO will carry out this notification. It's my honor and pleasure to do that. This prior consultation has a term of 2 months then for the EDPS to provide an opinion. And let's say that here our president thanked the supervisor personally during his presentation. I would like to personally thank Michal and Fanny and all the other colleagues of the unit for their extreme open-minded and open cooperation here, because what we ask for them is to have a process in phases. So instead of waiting until the end of this system be put in place and then consult the EDPS, who then probably would have a lot of comments and observations and suggestions, to divide this in phases and to do this consultation phase by phase. And I have to say that next to the formal consultation, there is a lot of informal calls, chats, and emails, and I'm personally extremely grateful for that, particularly to Michal. So he's not performing in front of a big audience, but he's highly appreciated. So moving to the next slide, I was asked to talk about challenges. Well, I could talk for a long time about challenges, so I just mentioned a few selection. In terms of legal challenges, I think, as Michaela said, this proposal was put together in a record time. So there are a number of things which are not, I would say, fully defined in the text, maybe intentionally because it was not clear, but this means that for the definition of some of the additional types of data and the amendments that are included in Annex 2 of the Eurojust regulation, it is not always 100% clear what is covered by these concepts, and I would say how we will implement that in practice in terms of principles, rights of the individuals, and so forth. From the practical viewpoint, as I said, for us, the main challenge is indeed how we ensure that every piece of evidence we receive is properly labeled as to the categories of data. As I said, we are working on that form. It means in practice that if a national authority would like to give us 60 pieces of evidence, they would need to fill in 60 forms. And I can tell you that doesn't make anybody happy. So we are looking into what are the practical ways of ensuring that. However, we do need the commitment and the resources of the national authorities here, because it is their responsibility to label this information. It is not our responsibility to try to fish out what we are receiving. So this is a very important point. It is also very unclear, to be honest, what is the volume of the data we are going to receive. We are in the very initial phases. We do not know if we are going to be completely overwhelmed by the amount of information received, or if there are going to be a specific selection of evidence we are going to receive. So this is still remains to be seen. Last but not least, I would say from my perspective, there is an issue of resources of the Data Protection Officer Office. Wojtek referred to the importance of the independence of the judicial authorities and the independence of the DPA. If I may refer to the importance of the independence of the DPO and to the need for the DPO to have sufficient resources to deal with this, to be really effective, because otherwise we will be unable to carry out our task properly. So I think in this, it is very important. And at this moment, I'm dedicating more than half of my time to this project. The same applies to my colleague Vaida, who, by the way, has her birthday today. So happy birthday, Vaida. I'm really sorry I'm not in The Hague, but I'm thinking of you. She's also dedicating about half of her time to this project, while we did not get any additional resources. So this is having a huge impact for colleagues. So moving to the end, what is the state of play here? Well, we did carry out the first consultation. As I explained, we work on phases, and the first consultation was submitted by me to the EDPS on the 13th of October. We are now impatiently waiting for the outcome of that. I know it will come soon in the next few days. And we are at the same time also working in all the steps to ensure we can go live, meaning that as soon as we get the green light from the EDPS, we can launch this first package that we had put in place. And this package includes not only the technical tools, but also the guidelines we are developing for the national authorities and for the national desk to ensure that they use this tool properly. And we are at the same time preparing the second EPIA for the second consultation on the storage tools, which is being hopefully refined and finalized as we speak. I left a version there before I left, and some colleagues are working on that. And let's say the target date for the second consultation, if everything goes well, is the 14th of December, assuming the College of Eurojust would approve on the 13th of December the package we are putting together. So we are all under pressure here. So last, I saw you a very beautiful slide put together by my colleague, Juan Manuel, who is our project coordinator. And you see there, just to show you the amount of work that still is to be done. So we are in the place where the red dot is there. That will be the end of 2013. The Russian flies are still here. And we are hoping to finalize this, well, let's say optimistically at the beginning, we thought at the beginning of 2023. I think the summer is starting to look as a more realistic possibility, but there is still a lot of work to go in all the different areas. So this brings me to the end, just by saying that, well, there are plenty of challenges in front of us, but as also expressed by our president, we are confident that in good cooperation with the EDPS, we will manage to overcome these challenges and we will manage to have a system in place which is not only useful for the practitioners and helping to ensure justice in this area, but also in full compliance of data protection. So thank you very much.
Thank you very much, Diana, and thank you for your kind words. And indeed, EDPS is closely involved, and thanks for involving us at a very early stage, keeping us informed about all the intentions. We are finalizing the opinion, as you mentioned. There are a few question marks, and I think you have referred to them also in your presentation, because with the new types of data, like audio or video recordings, it might be really difficult to verify if the data that is sent to Eurojust really fits the scope of the new provisions. Well, it might be also at a later stage difficult to. It has to be trained. I mean, it might be really difficult also to give access, actually, in this initial stage where you only store the data, to give access to the data subject. So I'm asking, well, do you see these risks, and what could be the ways to remedy that? I'm asking this question to Diana, but if any other panelists would like to jump in with some reply, please feel free to do so.
Yeah, now it is on. Well, obviously, this is one of the main questions we have now. I think there are two aspects to your question. If we are talking about does the information we receive really fit within the mandate of Eurojust, well, we are trying to put in place different measures to work on that. One is, as I said, this form. So the national authorities take a responsibility by telling us if the information they are sending us is about a certain category which fits within the Eurojust mandate. They also have to indicate the types of data which is involved. And there we have also in this form included the categories as they are reflected in Annex 2 of the Eurojust regulation. So if they have something that doesn't fit there, well, that should ring a bell already. Additionally, we are planning to use the possibility we have according to the Eurojust regulation in Article 23. We have 3 months for the national member to assess whether information is within the mandate of Eurojust or not. So we are putting in place systems to ensure that this assessment is carried out and that if within 3 months the data really doesn't belong to the mandate, it could be rejected. So that's a possibility as well. However, I will not say that we are not afraid of what this means in terms of resources. Particularly if we are talking about video files and so forth, how do you really verify that and how do you go through all that? So there are quite some questions there. In terms of exercising the rights of the data subjects, I think at the initial moment in which we receive the information, any possible request for access would be refused because we are talking about an ongoing investigation of prosecution in a very, very initial phase. However, individuals should have the right to request access if they so wish. So the question is obviously all these people will not be necessarily informed in advance about the fact that Eurojust has this information. So there are a lot of challenges and questions there. However, we will make sure that the necessary policies and notices and all that are in place. And obviously, if requests are received, they will be handled on a case-by-case basis and look accordingly. But the challenge is clearly a big one on that area.
Thank you. And yeah, I'm also wondering, because this new proposal, the mandate on war crimes, also assumes that you will have some relations with external partners. So I'm thinking here about the International Criminal Court that started its own investigation into the war crimes committed in Ukraine. So it is likely that Eurojust will have to exchange evidence with the ICC. In this case, well, what provisions on a foreign transfer will apply? What are the possibilities for this exchange? Yeah, well, let us maybe reflect commonly on this. Anna, would you like to comment?
Yes, maybe. I mean, this is, of course, something that the Commission already thought about and we have discussed internally. So I have to say, well, an international agreement between the European Union and the ICC on the cooperation with Eurojust was actually something which is on the what is it, the opinion of the Eurojust. So Eurojust has a strategy on this actually, and they requested us or the Commission to negotiate, well, the Union to negotiate such agreement. I have to admit, back then, several years ago, the priority was given to negotiating 13 other agreements with third countries, because at that time, actually, the cooperation with the ICC did not seem, well, the most pressing priority. On the other hand, of course, for an international agreement, it is necessary, of course, would be necessary that the ICC is also interested on that. And I don't say the ICC is not interested, but we just don't have information on that. And another possibility, which we have also started discussing to some extent, would be, of course, an adequacy decision to enable more structured exchanges or more systematic exchanges, because otherwise, of course, the ICC is an international organization. So under the requirements set out for international organizations, Eurojust, of course, can exchange data, but then it would be rather in individual cases. And maybe this is an area where I'm not an expert in, but of course also the member states remain or keep data ownership, and they are also, of course, under an obligation to exchange or to provide evidence to the ICC under the Rome Statute potentially. So this would also be maybe something which would be worth looking into further. Thank you.
Yes, Diana, would you like to add something?
Well, I think as to the legal framework, Anna clearly explained. So let's say the choices we have are either an adequacy decision of the Commission, which of course would make our life very easy if it happens. I know the European Commission is not very generous in providing adequacy decisions, so this might take a while. But I would say, yeah, the other option indeed would be some kind of international agreement between the EU and the ICC. We have had already, of course, some contacts with the ICC. In fact, they used to be our neighbor. We used to share a building in the previous building, and we have worked with them quite a lot in the past. But let's say their data protection system is very different from what we have in place. So I think it would require quite some work to ensure that certain systems are put in place that are, let's say, compliant with the EU standards. But yeah, for the time being, let's say the other option that remains is what Anna is saying. Let's say through the fact that Eurojust will receive certain evidence, we'll be able to know what is available in the different member states. And ICC could, of course, use the existence of this information, just the fact that they know there is certain information in the member state, to then bilaterally request the information from the national authorities at national level. We would have a different legal basis for exchanging this information. I think for the time being, that's going to be the most viable option, I think.
Yes, please, Michaela, because member states were mentioned here, so there's clearly a role for them.
Yes, thank you. Member states, that's my field. Yes, I maybe a little bit bring the perspective of the practitioners in here, or member states practitioners. Though the Czech Republic is, I don't know, it's the Czech Republic perspective, which means a small state where, for example, the terrorism cases are not so frequent. And we have quite, let's say, close contacts with the public prosecutors or judges, because there are not so many as compared to France or Germany. So maybe I would like to stress actually their perspective, which is basically, in general, the public prosecutor or judge actually will do everything possible to successfully close his or her proceedings. So the competent authorities have more in mind the result of the proceedings. Maybe I'm wrong, but rather than the data protection, or of course everybody understands that these data are sensitive, so they must have a high trust that these data will not be accessed by unauthorized persons. But that's something I think that they quite have in the agency like Eurojust, and also potentially the international authority like ICC is. The case we are talking here as regards the war crime regulation, I think this is a little bit extraordinary situation. We don't know what will happen. That's like one thing which has been mentioned here. Czech Republic is a state where actually there could be a lot of evidence, because we have a lot of war refugees in my country. So there are two possibilities, that the cooperation will actually happen through Eurojust, or it actually might not happen through Eurojust. So it really depends which way the each and every individual public prosecutor will decide to go. And so in this respect, the awareness raising will be very important. So in order to stress the role of Eurojust and the way Eurojust can actually assist. But as you have mentioned, as regards the cooperation with ICC, we have rules in place which are quite detailed as regards the data exchange with ICC as a direct contact between the competent authority and ICC. So maybe this could also be followed. And yes, let's see what will happen. Let's see how, if the public prosecutor will think more globally to have to actually reach the result in a more global sense to bring justice, or if they are more concerned with actually closing their own case, which can also be the case. And then it's a little bit different path here.
Yes, thank you for bringing in this perspective. I mean, of course, our role is to make it easy for the practitioners to close their cases in compliance with all the data protection provisions. But let me turn briefly and come back to the joint investigative teams. Actually, these are teams of prosecutors and law enforcement authorities of 2 or more states that are joining on the basis of an agreement to investigate a specific case. And these JITs, joint investigative teams, can also involve members from third countries. Then, in terms of data protection, the situation might complicate a bit because there will be exchange of information, personal data transfers to third countries. So what works here in practice is this new proposal, the new platform, also taking care of this aspect? Yeah, that would be my question maybe to Diana.
Well, the new platform will be a big improvement, I would say, mainly from the technical viewpoint. The legal issues are different ones than that, particularly if we are talking about third countries. And I think one has to understand that in the context of the joint investigation teams, the national authorities that participate are bound by their national law. So prosecutors who are part of the joint investigation team will exchange data with the third country in line with their own existing agreements at national level. And as we all know, the law enforcement directive did not affect the existing agreements which are still in place and in force. And most of those, all agreements don't contain any or not many data protection provisions. So this is a weakness of the system, but what they do is obviously legally correct. When Eurojust is involved, it might be different. Eurojust looks at the situation. We do have cooperation agreements in place with third countries, and that would be then applicable for the exchanges that Eurojust carries out. And we are also reflecting on a new initiative, and we were discussing that with some colleagues yesterday, which would be the introduction of some data protection clauses on the EU JIT model agreement. This is like a very new idea that we are considering. And of course, ideally, if the European Commission agrees with this initiative and sponsors us, I mean, I don't mean financially, but I mean by supporting the idea, it could become something that would be a standard, because then if those people who are applying for a JIT funding through the JIT platform, etc., with Eurojust would have to use this, that would be somehow a way of challenging that. So we are indeed, on a very preliminary basis, preparing this possibility that we could have those clauses included in the model agreement, and that could be a way of ensuring, let's say, appropriate safeguards. You can discuss under which article particularly and which letter of the regulation, but in any case, it would then facilitate possibly the cooperation with third countries, particularly for those with whom we do not have a cooperation agreement in place.
Thank you. Anna, would you like to add something to this?
Yes, only briefly. So indeed, Diana explained, of course, already well, the legal requirements in the first place for data sharing, and the platform is basically the digital tool to do so. But nevertheless, we have certain special safeguards for the platform for exchange of evidence with third countries, and actually by now it seems also international organizations, international judicial authorities, because of course they are a bit different because they're not bound to EU data protection acquis, and also, I mean, the controller rights need to be, access rights need to be differ a bit, and also exactly controllership for the data in the platform needs to be designed slightly different when it involves third countries.
Michaela?
Yeah, no. Yes, thank you. I only would like to add that, yes, indeed, the member states were quite interested in having quite detailed rules as regards the access to the JIT platform. But one thing, if the member states would not, or the competent authority would not like to share their data in this team, they just wouldn't do so, because it's important to stress that the data will not yeah, it's still the ownership. The ownership of the data is the competent authority or the member state. So if they will feel that, okay, this is not data which should be in the hands of a third state or international authority or anyone else, they will simply not do so. So yes, some safeguards are important, and the safeguards should be there in this as regards the access to the platform, because the third states or international authorities have a slightly different role there. It's still the member states who are in control there. So I believe that this will not be a concern of the member states or the authorities as such.
Well, thank you very much. I think we have heard about many challenges, but I guess it's important also to stress that with these challenges, also positive impact is granted by these proposals in terms of security of data, in terms of streamlining data flows, and in terms of building up the confidence in the member states and Eurojust. So we are waiting eagerly for the outcome of the negotiations. I think the second important thing to underline is that even if the data protection provisions of the Eurojust regulations per se are not being touched in these amendments, there is huge impact on what Eurojust will do, and yeah, the amount of and types of data that will be processed, and for us as the supervision as well, a new area to look at. But yeah, of course, we could discuss this for longer and not fully explore the topic. But for those of you who are in the room, there is an opportunity now to ask your questions to the panelists and yeah, ask them about their presentations, their views. For those who are online, you can send the questions via WebEx chat and we'll try to address them. But let's start with the public in the room here. Is there any question? I see a raised hand there. Can you please turn on your mic, introduce yourself, and ask the question?
Good morning. Okay, my name is Alessandro Alfaro. Though I'm from the parliament, but I'm not representing the parliament, so the question is not from the parliament. Sorry to put a disclaimer. One thing I noticed is that security is not data protection, though it can help for it. But notice the frequency in which secure appeared in the various presentations, because of course that's the one problem. And level enforcement and judicial are not the same. At the same time, what I was thinking is that for all this secure and this problem with access and who owns the information, can decide where it goes, etc., was when police do investigations, whether it's national or even there is EU exchanges, the information is classified. That provides a certain level of assurance and also a certain legal protection automatically, because automatically it's criminal law, is protected by criminal law. So I was thinking whether at a level both technical, the systems, for instance, etc., and at the level of the helping to have certain protection, certain rules already well defined, like the originator decides who can get access to information goes to. If it has already been considered or is maybe included, I did not read the proposal from the Commission, for instance, that eventually those systems could be considered classified systems and information then classified, which can complicate for the IT system, for instance, a bit the process of approval, because you need to get an accreditation, which is often not the fastest process in the world, as we say, but will already provide something, some kind of rules about the information is managed, about the systems themselves, all the security need to be, etc., and all new countries or new partners can connect, applying rules that exist already. So will be not being could reduce the work linked to defining new things in a way when it comes to the practicalities.
Yeah, well, can I just ask you to briefly specify a question here, because that's a valid observation you're making. I'm just wondering, yeah.
Well, if has been considered, if this, because I know if it's already been explicitly defined or not, if it will be possible to use this, if there is an idea of using this kind of putting the information as classified and automatically then apply those rules. And the systems in question will be then classified systems.
I understand that you're asking about the rules of using classified information into the new CMS and so on. Well,
If it could be classified and automatic, that can give you all a number of rules predefined.
I can try to give a brief sort of answer, but then I will maybe turn to Diana to supplement, because, well, in our supervisory activity, we have realized that Eurojust is not the level of police investigation anymore. At this stage, we usually have people being brought to court or being charged, and there is a different regime to deal with that. But there are certainly cases which are still classified, but these are not many, let's say, in the volume of the cases that Eurojust has. But Diana will probably know more.
Well, thanks very much. It's actually a very interesting question. And I think it goes indeed into what Michal says, the difference between intelligence and evidence and judicial information. I think if we are talking about intelligence, yes, a lot of things are classified, but it's very difficult to use classified information in court, right? So actually you need to declassify this information if you want to be used as evidence. So at some point of the process, you will get to the situation where this information is not classified, even in the cases in which initially it was. So I would say at Eurojust, we receive very, very little classified information. Through the years I've been there, we have rules on classified information. We have all the procedures in place, as you can imagine, to comply with the EU rules on that. However, it's very little information we receive which is really classified. Sometimes on terrorist cases and so forth, you could have specific files. But we do have what we have in place, of course, deriving from the law enforcement directive, is the fact that the national authorities will always define to us what we may or we may not do with the information, with whom it could be shared or not. And this, of course, applies through the whole process. So we will never be able to use certain information if it has been clearly said by the national authorities we cannot do that. And even in the cases in which by running our different systems, we would have the information that there might be a link, which can be relevant, like with the CTR, etc., we would always have to go back to the national authorities and says, it seems that there might be a link. Would you be then interested in us verifying that and checking this? So there is always the obligation to go back to the national authorities there. So, but indeed, yeah, using classified information in court would be a challenge, I would say.
Thank you very much. Is there anything you would like to add on this? No, I don't see. Are there any other questions from the room? I cannot see anyone. Do we have some questions coming from the WebEx session?
Yeah, we have some question. A very practical question, actually, I think, about understanding how this works. So we have one question about, let me see. When a third country transferred data to Eurojust, would all EU member states or other actors have access to it? Or could the third country limit the actors, EU member states who can have access to the data? So it's about how it works when you receive data from a third country.
Yes. Well, obviously, with third countries, we apply the same standards. So when they provide us information, they can indicate with whom it will be shared or not. If the third countries are countries with whom we have a cooperation agreement and a liaison prosecutor in-house, and these people then have access to the specific module of the CMS for liaison prosecutors, then they will be able then to put the information there and also to manually indicate on a case-by-case basis with whom they want to share. So I think, as Anna said at the beginning, the fact that any information arrives at Eurojust does certainly not mean that it is shared with the whole of Eurojust. On the contrary, we have a system which is extremely granular and goes really item by item on the sharing for each specific piece of data we receive, and that is indicated either by the national member, if it's a member state, or by the liaison prosecutor in-house. And when it is a country with whom we don't have a licensed prosecutor, this would be also specified in the way we receive the information.
Thank you, Diana. There is another question about the interplay or the impact of the right to erasure of the suspect on other, for instance, the victim, and a question about what happens in case a suspect would request his exercise the right to erasure. And would this, in cases, have an impact on the ongoing court case, whether it could be recovered. But I think I will abuse my right here and maybe ask you the question: have you ever received such kind of request, and how have you dealt with it?
Well, we have through the years, I can tell you. I could write a book on that, but this is for another occasion. But let's say, obviously, the right for erasure in the context of an ongoing judicial procedure is a difficult one, because obviously you can erase information which has been illegally obtained or which is not accurate, etc. But you cannot just ask, well, you can ask for it, but you will not obtain the erasure of information during the court procedure. I mean, the question is maybe interesting, but that's a very philosophical question linked to the whole discussion we had before, what the colleagues have explained about the possibility to keep information after somebody has been acquitted. And there, I think, is a possible question of somebody who would say, listen, I have been acquitted under national law. Why do you still have my data? And there's something that, from the human rights perspective, I think is a very fair point. However, it will depend on what are the obligations under national law to keep or not to keep certain information under criminal procedural courts and procedures and so forth. But it is for sure an interesting question. I can tell you we have never erased any information of anybody in the context of operational data. We have done it for administrative data, but not for operational data.
Okay, I think that brings us to the end of the first session. And at this point, I can invite you to a short coffee break, 15 minutes, and let's meet in 15 minutes back in the room where we'll start the second session of this day. Thank you very much. Thank you to all my panelists for their participation. See you all.
Good morning, ladies and gentlemen, once again, and welcome to our second panel of the day, the panel regarding the European Public Prosecutor's Office. Before starting with the panel, I would like to welcome the EPPO, Ms. Laura Convesci. Thank you for coming and making this moment for us. I would like to pass the floor to you immediately for your opening speech.
Good morning, ladies and gentlemen. I would like to start by thanking the EDPS for the invitation to address you at this conference on data protection and criminal law. I trust that many of you are familiar with the European Public Prosecutor Office, but let me say a few words about our institution, which is useful to put our data protection focus into perspective. The EPPO is the first transnational prosecution office. Our role is to investigate fraud involving EU funds of over 10,000 euro and cross-border VAT fraud involving damage above 10 million euro. This includes related corruption, money laundering, and organized crime offenses. Together with all the relevant national authorities, we have managed to integrate the EPPO into the judiciaries of 22 member states, and this is an extraordinary achievement. We have created what I call the EPPO zone, a zone where by implementing a prosecutorial policy, we are unifying the approach to EU fraud investigations, a zone in which we act as a single office with a specific working regime outside the usual channels of judicial cooperation. And in the EPPO zone, the budget and the rule of law are better protected, criminal groups are fought more efficiently, and as a result, we are safer. We started operation on 1st June 2021, and in the first year of operations, we have registered and verified more than 4,000 crime reports, seized more than €250 million, And we have currently approximately 1,200 investigations ongoing. This means many personal data, of course. 3 years ago, almost to the day, we had started small, really small. We had about 20 people in the central office, no decentralized offices, no European Prosecutors College. We had to already design an essential feature of our organization, the case management system, and this meant respecting the data protection rules. We also had to work on the EPPO rules on processing of personal data, on our internal rules of procedure and others, even before the college existed and these documents could be formally adopted. We had to ensure all the systems were appropriately in place before the start of our operations. We knew that we were not going to have the luxury of a slow and gradually start. We knew we were going to have an immediate and intense workload with cases coming in from the national authorities and from citizens to be analyzed and follow up. Therefore, the setup of the EPPO had to match the very definition of data protection by design. In this process, we worked closely with the European Data Protection Supervisor. It was my first contact with the EDPS and a very positive one. It was an example of supervision which included advice and assistance as well understanding for the specific aspects of a prosecution office. I believe that understanding the reason behind individual rules is important. It allows implementation and interpretation to be consistent, even in circumstances which may not immediately be crystal clear. We have therefore a data protection regime that I, as European Chief Prosecutor, am proud of. It is not only on paper, but also in a positive data protection culture of the organization. Being a prosecutorial office, it is impossible for us to work without processing personal data. This means that each and every one of our actions has a data protection aspect to it. This is an essential part of the fundamental rights of suspects, together with the respect of procedural rights. I firmly believe that these reflections on data protection at almost every step assist us and have assisted us. Let me recall now the EPPO's processes operational personal data under the lex specialis of the EPPO regulation itself. This legal framework travels with the operational personal data under the EPPO's control. The result is certainty, also singularity, as regards its interpretation. It reflects the uniqueness of the EPPO and our unprecedented legal nature of an independent prosecution office of the Union. We are not a coordinator, we are not a network, and we are not a new layer to improve cross-border cooperation in judicial matters. Our competence is a genuine transfer of sovereignty. We are embedded in the national judiciaries of 22 member states of the EU. We are a single prosecution office operating in 22 different member states, and this includes the control of personal data. What works for other agencies and bodies may not work for the EPPO, which can bring its own criminal prosecutions, start its own criminal investigations, and which must respect the fundamental rights of suspects and citizens as prescribed by a combination of EU and national laws. Considering the importance of data protection and the ongoing evolution of the EPPO, discussion and debate is always welcomed, and I trust that good ideas and reflections will come out of the conference today. For my side, I trust that we can continue to find answers to data protection issues in the same way we have started EPPO, with open dialogue with the EDPS, with transparency and with a clear understanding that even where there may be questions, the fundamental rights of citizens will always be protected and never in jeopardy. To me, that is the point of data protection in practice and the aim of its supervision. Thank you very much for your attention, and I'm sure that my colleague Stephen Reinders will give you more details about EPPO and how we respect the data protection rules. Thank you very much again.
Thank you once again, Ms. Koeshi. And with this, we would start our second panel of the day, so dealing with this new kid on the criminal justice block, the European Public Prosecutor's Office. This panel today will reflect on some key issues regarding the EPPO, data protection challenges, and the experiences of the first year of the functioning of the EPPO. Before we start, I would like to present our amazing speakers here today. Starting from my right, Ms. Vanessa Fransen, professor at the University of Liège and affiliated senior researcher at KU Leuven. She specializes both in criminal and data protection law. And also on my right, Mr. Stephen Ryder, the data protection officer of the EPPO. And on my left, Mr. Fabio Giuffrida, team leader in the General Criminal Law and Judicial Training Unit at Eurojust. My name is Nikša Stolic, also to introduce myself. I'm a legal and policy officer at the EDPS, and it is my pleasure to host this panel today. Let us start immediately. We have a lot of questions and discussions prepared for you today. Perhaps as an introduction to immediately start a short presentation of the EPPO, and here I would ask the floor for you, Fabio.
Yes, thank you very much. Good morning to all of you, and first of all, thank you very much for the invitation to the conference today. In my short presentation, I would like to set out some, let's say, general or explain some general rules on the functioning of the EPPO, and this would then allow us to discuss a bit more in detail the rules on data protection. I think I had a presentation. Yeah. Yep, super. Thank you very much. So, I mean, it's not an easy job to talk about the EPPO after the European Chief Prosecutor, but I will try my best. Thank you very much. Starting maybe really from the beginning, what is the EPPO? And this was already partially anticipated by the European Chief Prosecutor. The EPPO was established by a regulation adopted in 2017, and it became operational on the 1st of June 2021. So it is now about 1.5 years of operational investigations or operational activities of the EPPO. As the European Chief Prosecutor said, the EPPO is the Independent Public Prosecutor's Office of the European Union, which is responsible for investigating, prosecuting, and bringing to judgment crimes affecting the financial interest of the European Union. So allow me to stress a few aspects of this definition. First of all, the EPPO is independent indeed. So it means that the EPPO in its operations, it's independent from the member states, but also from the other European Union institutions, agencies, bodies, and offices. Just to give you an example, the European Commission sits in the College of Eurojust when it comes to non-operational matters, and so it does in the Europol Management Board. The European Commission does not sit in the EPPO College. So there is more, I would say it's more independent than existing agencies. And of course, this also brings to the fore different questions when it comes to data protection. The second issue I would like to stress is that the EPPO is indeed, as was said also by the European Chief Prosecutor, competent for investigation and prosecution of crimes affecting the budget of the European Union.
So what we call in our Brussels language PIF crimes, PIF standing for Protection des intérêts financiers, so protection of financial interest of the European Union. And the third, perhaps, element I would like to stress, which also, of course, has an impact on data protection issue, is the fact that the EPPO is a public prosecutor's office, meaning that the trial to determine whether the person under investigation or not is, the person under investigation is guilty or not, takes place before national courts. So there is an interplay between a European phase of investigations and national phase of trials, which of course creates some complexities in this interplay between national and European Union law. And at the same time, if I may, it's also in a way a testament to the uniqueness of the EPPO, which was mentioned by the European Chief Prosecutor, because it's quite rare, if not indeed unique, to have a supranational prosecuting office and then national prosecutors. If you think, for example, of the International Criminal Court, the International Criminal Court is a fully fledged system from the prosecution to the execution of judgments. Whereas here, the Europeanization, if we make also, it's only limited to the prosecution and the investigation and the prosecution phase. So, as was already mentioned, the EPPO is competent for crimes, for PIF crimes, and these crimes include fraud. So that's the most clear example of the clearest example of crime affecting the budget of the European Union, and this includes cross-border VAT fraud, where the damage is above 10 million euro. But it also includes other crimes as long as they affect the budget of the European Union. So money laundering, corruption, and misappropriation. So again, just to be clear, not money laundering in general, but only as long as money laundering affects the budget of the European Union. And in addition, the EPPO is also competent for organized crime whenever the focus of the criminal organization is the commission of PIF crimes. So as you can understand, the uniqueness of the EPPO is also linked to the sensitivity, in a way, of the topic, because it goes without saying that criminal law has always been considered the closest, perhaps, area of law to national sovereignty. And here, for the first time, we have member states accepting to give up on their sovereignty, at least when it comes to investigations and prosecution of these crimes. And so perhaps it's not that surprising that not all member states have accepted to do so, because the EPPO has been established by means of enhanced cooperation, meaning that for the time being, 5 member states of the European Union do not participate in the EPPO, those being Denmark, Sweden, Ireland, Poland, and Hungary. As you know, the reasons for not joining are different. Denmark enjoys a permanent opt-out from measures of the area of freedom, security and justice. Ireland, which participated in the negotiations, could have opted in, but it didn't. Whereas for Hungary, Poland and Sweden, it was a political choice. And Sweden might join next year, but this is now to be confirmed because there was a change, recent change in government. What I wanted to also briefly discuss, just to also to better understand what are the implications of the data processing by the EPPO, is the structure of the EPPO, which again is a unique structure, especially when you compare it to union agencies such as Eurojust or Europol. And the reason for that is that the EPPO has 2 levels. So we have a central office in Luxembourg, and then we have a decentralized office in each of the 22 member states participating in the EPPO. So, starting from the central office in Luxembourg, so that's the top part of the slide you see on the screen. In the central office in Luxembourg, we have the European Chief Prosecutor, so Laura Kövesi, and then we have 22 European prosecutors, so 1 per participating member state. The European Chief Prosecutor and the European prosecutors altogether form the college of the EPPO. And here again, unlike Eurojust, the College of the EPPO does not have operational powers. So the College of the EPPO is not involved in investigations and prosecutions. The College of the EPPO does not take decisions concerning specific investigations or prosecutions. So the the College of the EPPO is rather the management body of the EPPO, which takes decisions on budgetary administrative matters and adopts the internal rules for the EPPO. Then, still at the central level in Luxembourg, we have a smaller formation than the college, which is called permanent chamber, or better, permanent chambers, because there are 15 permanent chambers, which are composed by the European Chief Prosecutor, or one of her deputies, and 2 other European prosecutors. So, in Luxembourg, we have 15 permanent chambers composed of 3 people, European Chief Prosecutor or deputies, and 2 European prosecutors. And those chambers, unlike the college, are involved in the investigations and prosecutions. So it means that the investigations and prosecutions are actually directed by the permanent chambers in Luxembourg. And of course here, for those of you who are not familiar with the EPPO, you might wonder how, in fact, a permanent chamber composed by 3 people in Luxembourg is able to steer the investigations on fraud, for example, ongoing in, I don't know, Estonia or Italy. And that's the reason why the EPPO also has a decentralized level. So there are people working for the EPPO in each of the 22 participating member states, and these people are called European Delegated Prosecutors, so EDPs, so not EDPS, EDPs. And these people used to be national prosecutors and now work only for the EPPO under the instructions and the control of the permanent chambers in Luxembourg. So in case of fraud, for example, committed in Estonia, as I said before, the investigations will be carried out on the ground by the EDPs in Estonia under the control of the central level in Luxembourg. And maybe just to complete the picture, of course, at the central level, there is other staff. So we have the administrative director and then other staff, including Stephen, of course, and financial investigators, HR, and so on and so forth. So already the structure of the EPPO gives you the idea of the uniqueness, but at the same time, the complexity of the EPPO, precisely because of this interplay between the European level of activities and at the same time, the national one. So just to conclude on this introduction and then leaving the floor to the other speakers, maybe 4 key elements on the activities of the EPPO. The first one I would like to mention is the principle of legality, meaning that whenever there are reasonable grounds to believe that a PIF crime has been committed, the EPPO shall initiate an investigation. So the EPPO is in principle under an obligation to initiate an investigation in each and any case that might fall within its competence. And of course, this also has an impact on the budget of the EPPO, but also again, on the data protection side of the EPPO, because in principle, the EPPO does not have discretion, as it happens instead in some member states, to initiate or not an investigation. The second issue I would like to mention is the primacy of the EPPO competence. Meaning that if, for any reason, national authorities start investigations into PIF crimes, or such investigations were ongoing when the EPPO took up its functions on the 1st of June, then the EPPO can evoke the case or take over the case. So the competence of the EPPO enjoys priority or primacy over the competence of national authorities when it comes to PIF crimes, and the EPPO can, so to say, strip national authorities of their cases when it comes, of course, to PIF crimes. The third point was already mentioned, so I would just go very quickly. Here, as I said, the investigations are carried out by the European delegated prosecutors in the member state where the crime was committed under the supervision and direction of the permanent chamber, and whenever needed in cooperation with the European delegated prosecutors of other member states. And this all means that the EPPO works in accordance with a mix, actually, of EU and national authorities. And just to give you an example, the EPPO does not have its own police. The EPPO relies on national police authorities. This means that the EPPO really works in accordance with rules that are both to be found in EU law, starting, of course, from the EPPO regulation, but also, if not mostly, in national criminal law, being it criminal procedure code or code of substantive, so to say, criminal law. And one of the consequences of this is that, for example, when it comes to the judicial review of the acts and decisions of the EPPO, most of them, with very limited exceptions, are actually to be reviewed by national courts. So all the decisions taken by the EPPO, for example, the decision to interview a person or to order or to ask for wiretapping, all these decisions must be reviewed or should be reviewed by national courts, which, as you can understand, it's again testament to the uniqueness of the EPPO, because in principle, all acts and decisions of EU bodies should be subject to the judicial review of the Court of Justice. So I would stop here, but happy to take any question, and thank you very much for your attention and again for the invitation. Thank you.
Thank you, Fabio, for this important overview. I will just again remind, as Michal said, we will have a question and answer session after the presentations. To go immediately a little bit into the future and to complicate things a little bit more, as a quick warm-up question for all of you. It was said in the EPPO annual report, and Ms. Laura Kovescio also mentioned it in numbers, that EPPO has a significant success so far, and it brings a decisive advantage to law enforcement in cross-border investigations. So having this in mind, perhaps your thoughts and for the calls for the extension of the EPPO competences in the near future. We saw the Commission already putting on the table a couple of years ago terrorist crimes. Then a couple of months ago, the European Parliament called for a green prosecutor regarding the environmental crimes. And only yesterday, the German and French ministers of justice also are calling for the EPPO to have the breach of EU sanctions within its mandate. So perhaps from your perspectives, a brief comment. Let's perhaps start with Vanessa.
Thank you very much. My first concern with extending the EPPO's competence would be that, as has been explained by the previous speakers, that it's still a very new body with a very hybrid regime that is challenging in many respects, not only from a data protection perspective. And so perhaps first give this new body some time to grow and to sort out certain challenges before adding more offenses to its material competence. But that would be my cautious approach. Terrorism, I'm very happy that it's off the table because it's a new body again, and terrorism is a very sensitive area where you need first to create trust among all the players that are involved to share their data and cases and willingness to cooperate. So I would be very cautious in extending, but perhaps in 5 years' time, things will look very differently, and well, let's see then.
Thank you, Vanessa. Perhaps to hear from Stephen.
Yeah, thank you. But I think mine is super short because there's not much I can, as DPO, would feel very comfortable contributing to that at this moment in time.
Thank you, Stephen. Then we'll proceed to Fabio, perhaps from the Commission side.
Yes, thank you very much. let's say that the position of the Commission for the moment vis-à-vis the possible extension of the EPPO competence is that the Commission is open to consider this idea. Although for the moment our priority would be to ensure that the EPPO, precisely because it started only 1.5 years ago, can work efficiently in accordance with the current mandate. But again, we are open to consider this idea. Just maybe to put this issue of the extension of the competence in context, of course, we have to bear in mind, first of all, that such extension of competence could happen only if there is unanimity in the European Council. So it means unanimity by all member states of the European Union, including non-participating ones, because in essence that would be an amendment of the treaty. So, of course, this already gives you the idea of the political stakes there, considering that some member states that do not participate in the EPPO, whether they would ever support an extension of the EPPO competence, considering then when they would join, if ever, they would be bound, of course, by the extended competence of the EPPO. The second issue is that the extension of the competence could only cover cross-border crimes, and that's a difference with the current mandate of the EPPO, because in principle today the EPPO would be competent for PIF crime even when they only affect one country. Whereas for the future, the treaty only speaks about competence for cross-border crimes. So among the three that have been mentioned, perhaps, but that's, I would say it's my personal idea, for sure environmental crime, at least in serious cases, it is cross-border, at least it has cross-border impact if you think of waste trafficking or the most serious case of environmental crime. And the same would go arguably for a violation of sanctions indeed. Whereas for terrorism, as Vanessa said, it's off the table. So I didn't say it, but indeed, let's say that it was not one of the most successful initiatives of the Commission, but we never know. And the last thing I would like to say is that, of course, when the EPPO regulation was approved, a few months earlier, also the PIF directive had been approved, meaning that there was an instrument that harmonized the definition of PIF crimes. And of course, it would be at least desirable that if the competence of the EPPO were to be extended, there would also be a similar harmonization of substantive criminal law, because otherwise we would have a very odd case in a way of a European body that would be competent for a crime that is defined in very different way across the participating member states. And the directive on environmental criminal law is already being discussed in the Council, as you know, whereas the one on violation of sanction has not yet been adopted by the Commission. But as you have heard yesterday, the Council agreed on adding violation of sanction to the list of the criminal offence in the treaty. So the proposal should come out soon. So I will leave you with this cliffhanger, and thank you again for the question.
Thank you very much, Fabio. So perhaps from the future, let's go back to the present. Stephen, you have been granted the honor of being, and you will be remembered as the first DPO of the EPPO. So this was, I imagine, a big responsibility for you to set up the data protection framework at the EPPO. Could you share a little bit about the challenges and the experiences that you faced during this first 1.5 years?
Yeah, happily and thank you. And I guess, I mean, if that is the legacy, I guess there's worse things. I'll take that one. And I'd like to also start by thanking Fabio for the introduction, because he did two things that is one of the areas where we struggle a lot with, which is first of all demonstrating the level of complexity involved in this operation, where I think if anybody had proposed it exactly like this when the EPPO was adopted, people would have had a few more questions before they said, sounds a good idea, let's go ahead with that. And the second aspect directly related to it is the clarification that is implicit, the way it was presented, is that we are not Europol, that we are not Eurojust, and we are also not Olaf. And try as you might, the reference framework for anybody operating in the EU environment are those three bodies. So to everybody, depending on your own background, yeah, so they're like Europol, there's like Eurojust. And that has really taken a big amount of time with our partners, with the public and general terms, trying to make clear that we are not the same. It goes from very practical levels, in one, from the level of cooperation that we have. So this is not a cooperative relationship in the way that the other bodies are. Of course, we also cooperate, but there's obligations to provide data. We prosecute, we investigate, we don't help. And this is a big fundamental difference also when you start going into working arrangements about exchanging data, where it takes a lot of diplomatic skill, so I'm not involved in that process, of demonstrating that this is not really an exchange of information. This is really a practical question of how will we get the data from you to us that we need as a law enforcement body, if you want to call it that. And it's the other benefit to that, but I think we'll come to that a little bit later as well, is that we don't have, thankfully, a number of the problems or challenges that Eurojust and Europol face as a result of the limitations of the data they may process. So that makes a dramatic difference, which is very hard to explain if you've not been working in the Eurojust regime and then in the Europol regime and now at the EPPO, where the amount of conflicts and challenges you have with those two bodies, you do not have, thankfully, in our environment. So that's nice, but we have different ones. So I'll go back then to the early days, and the question here is not only what is early, because in my view, this is still dramatically early. And I think this is also a testament to the success of the legislation, quite frankly, because we have turned the complexity, as described, into an operating business. We've been operating for 1.5 years and operating in the sense of bringing prosecutions. There is no environment in which you are challenged more every step of the way than in prosecutions in front of courts. And all of that has been very successful. I think also here from you don't need to look for challenges. Data protection is a subset of challenges for the EPPO, but it's certainly not the only one. But it was a big one at the early days. So in that sense, only the picture to demonstrate it's not quite clear who is who in this, if someone is running away from the rest after having spread the gospel. The nicest way I thought about introducing the EPPO data protection legal framework is in the words of the EDPS. And the EDPS, in its annual report of 2020, called it a challenge for us to be supervised based on our multi-layered legal framework and inhomogeneous structure with unprecedented scope, multiple references, and a particular challenge. Fully correct. So I read that, not even having been appointed DPO yet at that point, and thought, yeah, this is nice. We have the sympathy from our supervisory authority, so that is a good starting point. But I think, in fairness, it's also accurate in the sense of the relationship that was built up. To give you an idea, the early challenges, and again early because these are ongoing. I mean, these are not challenges which will suddenly disappear and they've been ticked and solved, so all is well. All is very well, of course, but there is still, unsurprisingly, a very large amount of questions that are not yet directly addressed. The very first point is that we have two different data protection legal frameworks. And here, generally, I stress that I think this is also for good reason. But of course, it comes also with challenges. We have a separate one for operational. We have a different one for our administrative processing. As a bonus, we also process it consequently within the member states themselves. And not only is that already a challenge, but of course, there you also have differing degrees of environments in which you are introducing your data. You have very developed and high-tech IT systems. you have legacy systems, shall we be generous, and you have some which have basically no IT conduct. So there's security through redundancy, if you want to call it that, but you're trying to operate on the same level in all of these different environments. So that's a challenge for sure. The bigger challenge, though, is also, again, that there is no precedence and there's nothing comparable. And this has led to two situations. Generally, people either get a little bit scared of the emptiness and go to a reference framework they know, which is then Europol, Eurojust, or OLAF. Or the way that we're trying to do is to fill the void proactively by having our rules adopted, by having a lot of conversations with the EDPS, by having a lot of discussions also with the practitioners about what is it that is needed. Because again, the vision of the EPPO, when it was adopted, compared to the vision by the chief prosecutor, compared to how we are operating now, are two very different or multiple different stages, shall we say, of development. And of course, then the legal framework has thankfully, in my view again, given us sufficient breathing room. So this is also, I think, something very, very nice and positive for us, that it gives some air to breathe. And I think without that air, there would have been absolute suffocation of the EPPO, and there would have been no way you could have worked at all, let alone compliantly. Well, the other problems you have, and this is, I mean, this is, Diana already said it in the earlier session. I just could go on and on for a while, but the highlighting ones, there was no real budget. So this is also a lot of the aspects. And this is not always, I don't want to be seen as being critical here. But the EPPO was set up on a minimalistic perspective, should we put it like that, in relation to its own IT environment. If you look at the original budget proposals, they were not very generous. We do not have our own IT environment yet. So we work, and we've been generously supplied by equipment from the European Commission. But that also means it introduces an environment which is not in our control. It introduces an environment which is not accredited for operational personal data processing. It introduces a layer of additional complexity on a practical level for the delegated prosecutors or operational colleagues who are given a laptop or an IT environment in which they may not use operational personal data. Which at the same time, however, is still working on a case management system, which was also not ours, but was a pre-made system deemed to suit most of our needs. But you're still stuck with the basics and you develop it a little bit further. So in a positive sense, it makes sense to not invest heavily in an area before you actually know what you will need and what your requirements are. On the other hand, of course, it can be a reasonably painful transition system. And for me, the biggest problem on a practical level is the buy-in of the users. Because if you have frustrated users, they will want to take shortcuts. And especially at the very beginning, that is a horrific danger, at least in my view, to start off as the starting point of your operations as a data protection awareness. The other two areas I'd still like to flag is there was no gradual rollout. So this is not something, we increased and well, thank God we only had 10 cases this month because then next month we can learn from these. No, this was really from overnight a full-on start. And not only in one or two member states, but in all of the ones at once that we were, that are participating. So there was not much room to learn from mistakes. We are learning at the moment, and there's also nice and continuous dialogue ongoing about our requirements, because they change. Some of the things you assume you will need data for, you end up not needing at all, although you've invested a whole lot of time in developing something which actually now you realize is not needed. On the flip side, you've set yourself some very strict time limits because you didn't anticipate that area to become a problem. But all of a sudden you find yourself in the opposite situation. But I think this is also part of the challenges and the joy, from my perspective, of being in such a volatile environment and volatile in a positive sense. The most recent change we have is then dramatic growth, and here I stress this is my personal view, and this is the benefit of independence. The EPPO will never see growth as negative, so, but it's certainly a data protection challenge also. If you go from 20 people, and now we are approximately 400 people, and this has happened over the past 3 years. During the past 3 years, 2 of which was Corona, where we've had colleagues coming to the office for the first time basically this year, although they've already been working for 2 years. And you struggle at times to make sure that everybody gets the same level of training, that we have consistency in our application of procedures. And this would be a challenge for any organization, I think, but let alone at this pace. A little bit about what I tried to do about it, because you start off and you're pointed and it's okay, let's see then. But at the very basic, I think you see that you cannot do everything at once. You are also, because of the budgetary aspects alone. So the key aspect to me was the development of a positive data protection culture, which to me started with trainings and establishing approachability. So trying to build hard against possible preconceived notions of what data protection is, especially in a law enforcement or prosecutorial environment where contact with data protection supervisory authorities may have been minimal in practical aspects, let's put it like that. So I spent a lot of time really being approachable, trying to be supportive, doing a lot of things which are not necessarily the DPO's job, but you start drafting people's records for them. You accept, I think, that you are more of a hand-holding guidance to the extent that is possible. And what has been ultimately crucial, though, is the buy-in, not only from the users, but also from management. So also there, that has been very clear from the beginning, and that feeds down, and that was, I think, absolutely was essential and is essential. But the main aspect of my trainings was also not in line with Article 55 usual, but the point was trying to explain the why and the observation and the thinking behind the data protection provisions in place. And that, I think, allowed a deeper understanding, I wouldn't go as far as saying appreciation, but at least an understanding of the provisions in force and why their work is being, in their view, at times restricted, maybe. The other aspect that came from the positive culture was a lack of time bombs, so what I called them, which is if you are in an environment which is completely untested, where you are the ones who are making the rules and establishing the practice as the first delegated prosecutors, as the first European prosecutors, it is very tempting to go straight for the result, even if you don't have a proper mechanism yet maybe to exchange personal data of an operational nature with someone you really want to exchange it to. Well, let's just do it. And these little things where you know nobody will probably know for a year, maybe even 2 years, but at some point they will blow up. And the flip side to that is to use the momentum we have at the moment, to use the support and understanding I'd like to think we still have from our supervisory authority, to document things, because there is an acceptance that you cannot set this up and foresee every single circumstance and have the best rules in place for each of these. But the alternative to that is either then not to do it, or to take the background and the why behind it and proceed to be as loyal to that and as loyal to the risks as you possibly can, and document it all properly, so when it comes to time for change, that can then be done. I'll leave it at that, other than 2 more points, which is something I've stressed in every single training, and that has stopped quite a bit of complaining or abuse of data protection as I see it, because there was a very quick phase where data protection was the reason a lot of things suddenly couldn't happen. And there was always, Steve, you always say no, and I don't think I've said no at all, actually, in those terms in a long time. But you start realizing that it becomes an excuse, and I was addressing that also very proactively. And I think that has also helped in that relationship, of making it clear that, yes, there are, of course, always concerns, but I will not be made, or data protection is not the scapegoat behind a lot of things. If you want function A to work, it can be done. That it's done like this is a design choice, not a data protection choice. And that, I think, was also a crucial aspect. Yeah. But of course, all of this, I stress this, is, of course, there's always uncertainty, but there is never in this uncertainty anything that is, in my view at least, and I say this consciously, as a detriment to the data subject, including the exercise of their rights. So this is always, to me, a fundamental given. And of all the uncertainties and complexities we speak of, I do not consider those to have been or to be in jeopardy at any point. Then the last things I've learned, if you want to see it in a self-reflection point, I found it, of course, apart from the things that I expected of the role of the DPO and the added value and all of these aspects and then your statutory duties, it was surprising to me how much data protection, especially in the state of having nothing and creating the entirety of the EPPO, was a very helpful tool by forcing a deep and detailed reflection where that may not have otherwise occurred, even outside of the data protection context. To have the independence and the corresponding job security, to also be the, at times, unpopular person to ask, well, why? Or are you sure? What exactly do you mean by this? And I would like to think that has focused a few minds. I'm sure a few colleagues would have been and still remain upset. But the point being that if you have nobody asking that, then you may have ended up with a lot of choices that you will have regretted later on, or would have had to reverse in any event at a later point. So this is, to me, something that was very helpful. Personalities matter, and that is simply the case. I mean, for every organization, you need to adapt the tone. I'm also sure that my tone will change. I'm also sure that if we have this conference again in 6-7 years, if I'm still DPO, then my tone may also be dramatically different and less smiley and, I don't know, a bit depressed. But I would hope not. But the point is, I think here you have a lot of momentum. You have a lot of buy-in from the organization and the individuals actually processing it. And it's a very exciting area and time to be active here. The EPPO is a massive game changer, I think, on many levels. I think also in relation to data protection, specifically in relation to, I didn't put that on the slide, but the question of consistency of interpretation in relation to what member states may do in a law enforcement context, and the same interpretation maybe not always being the same at EU level or the other way around, or even amongst the member states themselves. That is certainly a big challenge. And I think the EPPO is kicking off a bit of reflections there. That is also essential. And to me, it's very essential that indeed, also for me, there is an environment in which to talk to people. So if you are of a constructive mind, then please feel free to reach out. And I hope I've kicked this off to a little bit of a approachable start, without again stressing that, of course, with all the joviality, it is, of course, at the heart of the EPPO's functioning and ultimately also in its own self-interest to be more compliant than compliant, because anything else would not only be violations of fundamental rights, but would ultimately also jeopardize every single prosecution it undertakes. So thank you very much.
Thank you, Stephen, for this very interesting and insightful overview. You've mentioned data protection challenges in your work, and perhaps to throw back a hot potato in your hands immediately, the issue of categorization of personal data of the EPPO. So the EPPO regulation calls for distinguishment of different categories of data subjects, as well as personal data based on facts and personal data and based on personal assessment. Could you tell us a little bit to what extent do you see it possible and applicable to categorize personal data in the context of the EPPO, and do you have some experiences with the collection of a large non-categorized data sets?
Thank you, and happy to do so, of course. From my perspective, this is an area that I was mentioning before as a nice, well, it is now also a nice example of something that is not as concerning for the EPPO as it would be for Europol or Eurojust, for example. To us, the obligation exists, certainly, and it's an obligation that exists in its own right, because of course you need to pay a high degree of attention, and there's high degrees of sensitivities attached, and also you don't want to subject individuals to more processing than is needed. So it is absolutely crucial that you distinguish. But to us, there are no legal consequences attached to the categorization of the individuals. So for us, we have a limitation, if you like, of categories of individuals that can go into our index in the case management system, and that can be cross-checked. But there is no prohibition following from the lack of ability to assign a certain data categorization. And the second aspect to that is also we don't have that many sets, maybe yet, where that would become of heightened relevance. Because we do not operate, we don't have a big intelligence database. We have the individual national case file, which is the actual investigation. So by definition, it is more structured than already, because at that point you will already have a rough idea of who is in what role and so on. And in that sense, in our case management system, we reflect the national case file itself. As such, the importance is certainly there, but the problems faced by others in that area specifically are thankfully not ours.
Thank you, Stephen. So basically listening to your experiences and also having in mind the Commission first report on the application of the EU DPR, where the Commission basically calls for the consistency and minimization of the fragmentation of data protection rules. Ms. Kovesi already touched upon it in her speech. Perhaps from your respective perspectives, is standalone data protection regime for processing operational personal data for EPPO justified? Perhaps to go to Vanessa to give you a little bit space, Stephen.
Thank you, Nixa. Well, as most of you who have read the Commission report evaluating the implementation of the Law Enforcement Directive will have noticed, this first evaluation is rather superficial and, in my view, a first exploration of what's happening. And I think that this first exploration is probably also taking place or will take place within the EPPO in some time from now. So is a separate regime justified? I think it was probably the only way to go about. Looking also at Europol and Eurojust, even though we cannot compare, I know, Stephen, but looking at that you have a very different setting, I think a sui generis regime is absolutely justified. But it is a very complex sui generis or autonomous regime because of all the back and forth references to national law, and national law should be in compliance with the Law Enforcement Directive. So you get this very interesting patchwork, interesting from an academic perspective, but also taking into account that, as I think Fabio said in the beginning, that the EPPO is constantly cooperating with national authorities, and whereas within the EPPO, Stephen is creating a positive data protection environment, which is extremely positive. Law enforcement authorities, customs authorities at national level don't necessarily have the same mindset. When I had some interviews with law enforcement authorities, including judicial authorities at national level, it usually doesn't come or result from those discussions that they see data protection as something extremely positive. So they rather see it still as constraints, as Stephen perfectly illustrated, whereas it shouldn't. So I think to have an autonomous regime is probably the only way. The question now is how to implement it, how to apply it, and how to fill the gaps that are there, and how to clarify the interpretation of this strange bird that is the data protection chapter in the EPPO regulation.
Thank you, Vanessa. Perhaps, Fabio, if you would like to respond, and perhaps an additional question for you. Does the Commission have in mind, do you think any changes to the EPPO regulation in the near future are necessary?
Yes, thank you very much. So on the issue of the sui generis regime, I would agree with what Vanessa said, but I mean, I know there are also other colleagues from the data protection unit here, so happy also to hear their views. But this was the choice that was made, and by the way, the data protection chapter of the EPPO regulation is the longest one in the EPPO regulation, which adds one more challenge maybe to Stephen. In terms of possible changes to the EPPO regulation, we are aware that there are some issues that are not actually, how can I say, do not really allow the EPPO to be as effective as it should be. And these issues have been flagged by the EPPO already on different occasions, and they concern, for example, just to name an example, the cross-border cooperation within the EPPO. For the moment, we have not been flagged any specific issue concerning the data protection chapter, but maybe, Stephen, you will have some surprise for us today. But for the moment, the Commission is conducting an evaluation on the regulation. So I would say that the decision on whether there is a forthcoming amendment will be taken at some point next year. So we also want to see a bit how the activities of the EPPO develop before taking this decision, bearing in mind, in any case, that the deadline provided for by the EPPO regulation to revise the regulation itself would be at the latest 1st of June 2026. So that's the time frame envisaged in the EPPO regulation. Thank you.
Thank you, Fabio. Stephen, do you wish to respond?
I'll keep it reasonably brief, because indeed for me, it is very, very, my personal view, premature to even reflect changing an existing regime before you've even properly understood or implemented it, to understand the differences that may be problematic in case it would be doing so. So to me, I would, at least at this stage, be very concerned about proposals to do exactly that, precisely because nobody really yet knows what that would mean or the consequences it may have. And I don't see any positive side on the opposite that would balance out the risks. Yeah.
Thank you, Stephen. And for our final part of this panel, let's now have a closer look on the implications of the EPPO structure for data flows between the EPPO and the various national authorities, and the exercise of data subject rights in the context of the EPPO investigations. And Vanessa, you have the floor.
Thank you very much again. I've selected a few topics for discussion today for this short presentation, but a number of them have already been raised, so that will allow me to go further and leave some time for questions and discussion. I will just briefly represent the data protection legal framework, but Stephen has already done so I can almost immediately go to the data flows and the possible scenarios and implications, and then touch briefly on data subject rights, the theory, but mainly what might happen in practice, and finalize with some questions for discussion. So as Stephen said, there's two different regimes. One for operational personal data, which is the long chapter in the EPPO regulation, and then a separate one that is the one for administrative personal data that is the same, that applies to the other EU institutions and agencies. So the legislator wanted to have this separate regime, as has been explained, and during the discussion, the question just a few moments ago, this is probably the only way to go about Nonetheless, when taking a closer look at this special regime and to have discussions with people who negotiated it, I noticed that the people who negotiated the EPPO regulation were mainly focusing on the other chapters and not so much on the data protection chapter, and that the data protection chapter was actually added or brought in by the data protection experts. So if you ask a number of questions that are quite relevant, practically relevant, legally relevant on certain rules that are in this chapter on data protection in the EPPO regulation, then even main negotiators of this regulation sometimes didn't know the answer, which shows that as Stephen said, would all parties have accepted this text if it would have been initially on the table? I'm not so sure. Here, the question, in my view, is even more specific. Does everyone understand or have the same understanding of the rules that are in there? Because during my previous work, I noticed that there are some diverging interpretations. So this gives you an idea of how it looks like. So you have the EPPO that is already governed by two different legal instruments when it comes to data protection at EU level. But since the EPPO regulation is also referring on the number of occasions to national law, the national law has to be in compliance with the law enforcement directive. There will be cooperation with various national authorities. There will be information requested or given, exchanged by EU institutions, bodies and agencies that have their own legal framework. I mean, the regulation of 2018, and some of them will have a specific regime like Eurojust. So this gives you an idea of the different links that are there, which is a menu or a recipe for a very interesting dish. Whether it will taste good, the future will show us. To know how the rules interact, since there are different rules in there, not just specific rules, the sui generis regime, one has to refer obviously to Article 5, Paragraph 3 of the EPPO regulation that clearly sets that the EPPO regulation is EU law and so prevails over national law, but only to the extent that a matter is regulated by the EPPO regulation. And since in the data protection chapter, on a number of occasions, reference is made to national law, the boundaries between the EU rules and the national rules may not be always so clear, even though this rule is a perfect translation of what we all know from EU constitutional law. Why is the reference to national law so problematic? Because, as already highlighted, national law has to be in compliance with the law enforcement directive. And as the first evaluations of this instrument have shown, there are still a lot of blind spots in this implementation. A number of issues have not yet come to the European level, whereas I know from that they exist at national level. We all know our own legal system obviously best. So I know there are a number of problems, for instance, in my own member states, Belgium, that have not yet been highlighted or identified in these first evaluations, even though people at national level know that those issues are there and they will come to the surface at some point. So ticking time bombs, to refer to what Stephen said, there might be some. If we look at data flaws, the data flaws between the EPPO and its different partners, national authorities or EU institutions, agencies or offices, well, considering this legal framework, there will be clearly flaws of data, data going back and forth between different levels, between at the European level, between the EPPO and other EU institutions, but also between the national level and the EPPO. So there will clearly be different streams of data, and to these different data, different rules may apply. Depending on whether the EPPO will cooperate with the police. As has been said before, the EPPO doesn't have its own police forces, so relies on national police officers and financial experts in the field to conduct its investigations. But the same goes for customs authorities, which also have very, very different powers, considering if you look across the member states, some even have prosecutorial powers, criminal prosecution powers, like, again, my own member state, but also Luxembourg. And so they all work in their own way and have their own data protection rules that apply. If we take a look at, considering that there are different partners, stakeholders implied, if the EPPO requests national authorities to proceed to a certain investigation measure, it will be the national authorities that will investigate, collect data, and send the data back up to the European Delegated Prosecutor, who will put it into the case file, and not only a paper case file, but also an e-case file. So it will be clearly the EPPO who is processing the data, because the data have been created for the EPPO upon the request or the instruction of the EPPO. But it could also be that the EPPO is just requesting information, data that is already pre-existent at another level, whether it's at national level or at EU level. I don't go into the cooperation with third countries or non-participating countries, not to complexify. But in that case, the EPPO will not be the data controller for the pre-existing data until the data comes into its own case management system, enters into the case file. But this may only be a part of the data that is controlled by the authority that is providing for that data. So then in that case, you will have different controllers, and the national authorities will not just be a processor of data. This has raised before the question of joint controllership. This question might be addressed by the third panel. Is there need for joint controllership? Because during previous research, I noticed that at the level of the member states, the interpretations of the need for joint controllership has surfaced, has been raised. That would, of course, have a number of legal implications. So it remains to be seen which scenarios, but in each of these scenarios, different rules may apply, and the controller processors of data may be different ones. So there may be various ones. If we look at some, let's say, particularities at national level in the interaction with national authorities, especially when it comes to the supervision of the data processing by the EPPO. We know that at EU level, the EDPS is competent. So whenever the EPPO is the controller, the data controller, EDPS is supervising. But since there might be situations where there are several controllers, this also raises the question whether national supervisory authorities shouldn't come into play. And we all know the question is yes. The difficulty at national level, if we need a coordinated supervision where the question is positively answered, is that at national level there may not be just one supervisory authority, but there may be several supervisory authorities. So you will have a data protection authority at national level, but this data protection authority may not be competent, well, is not competent for courts acting in their judicial activity as provided by the law enforcement directive. And for other independent judicial authorities, national law may also provide that the National Data Protection Authority is not competent when these independent judicial authorities act in their judicial capacity. Now, the interpretation of in their judicial capacity, there has been previous research, but it already shows that some member states tend to interpret this very broadly, whereas initially this was not the intention of the legislator. But it means that at national level, for courts, but also for public prosecutors, for the police, this may also be true. In some member states, you will have different national supervisory authorities. So to have a coordinated supervision, this means that these different supervisory authorities at national and at EU level should cooperate. I would also like to point out that for some judicial authorities at national level, there is not yet a national supervisory authority. And I refer to my own member state where there is no supervisory authority for the public prosecutor's office, and seemingly there's no urgency to deal with this matter so far.
Thank you.
Sure.
Thank you, Vanessa, for this very interesting presentation and food for thought. Perhaps one question, supervision will be dealt in the third panel, but perhaps a short question for the Commission. Vanessa mentioned that still we have no supervisory authorities designated for the public prosecutor's office in some countries. So Fabio, do you perhaps have some inside information on was this issue discussed during the development of the Commission first report on the functioning of the law enforcement directive?
Thank you very much. I can be very brief. So the issue is not covered in the report, but I know it's under discussion, but I would actually stop here and maybe give the floor or for the later panel to my colleagues from the Data Protection Unit to better address. Let's say that from the EPPO perspective, we didn't look into that. Thank you.
Thank you, Fabio, and this is considered given the time we have for this panel. So basically here I would like to thank our panelists for the presentations and open the floor for possible questions from the audience, whether here or online. We have two questions. First, I think you're right, and then I'll...
All right. Thanks. My name is Juraj Seifert. I'm a doctoral researcher at the Vrije Universiteit Brussels. I would like to ask primarily Fabio, or I would like to push you a little bit. Sorry about that, but I would like to push you a little bit on this. Well, what seems to me an unwillingness to change, while changing the EPPO regulation, unwillingness to change its data protection regime, or insisting on the standalone data protection regime, because I'm not a big believer in standalone data protection regimes. I think if law enforcement authorities in Europe, in the EU, should cooperate and share data with each other, then I don't see the need for having such a fragmented legal framework. And I think the reason why this was adopted as it was in the EPPO regulation was simply because it was adopted prior to the reform of the regulation 45/2001, meaning prior to adoption of the regulation 2018-1725. And that regulation, which you mentioned, and Niksha asked you about its review that was carried out by the Commission, according to Article 98, that review was carried out, and Article 98.2 says, paragraph 2 says, on the basis of that review, and in order to ensure uniform and consistent protection of natural persons with regard to processing, the Commission may submit appropriate legislative proposals, in particular with a view to applying Chapter 9 of this regulation to Europol and the EPPO, and including adaptations of Chapter 9 of this regulation if necessary. Now, I understand that the Commission has the prerogative of legislative initiative, that no one can make you make proposals, and that the co-legislators also cannot make you make proposals, and here they express their willingness to have more uniform legal framework for data protection to the extent that they can without touching upon your prerogative legislative initiative. So in the context of, if you already are proposing some changes to the EPPO regulation, whatever they may be, to what extent can you actually insist on your prerogative and neglect or set aside this expression of desire of the co-legislator to have more uniform legal framework, and say, no, we think that the EPPO data protection regime standalone should not be reformed, it should be kept as it is. But anyone else can reply as well. I mean, the question is for Fabio. He holds the pen, so the question is, holds the pen.
Well, I mean, I hold the pen literally, but that's it, I think, because that's mostly for, I think, for Anna. But I mean, from our side, I wouldn't say that there is unwillingness to change the regulation. I think the point of the Commission is that since the EPPO just started 1.5 years ago, let's see how it works. Let's see what are the main problems. And then we start thinking about amending the regulation. And the reason why all regulation provides for some time to assess is because before changing it, you should see how it works. That said, I understand that's kind of the same position of Stephen. So if to the Commission some issues are brought. So if some issues are brought to the Commission attention, then I think we will look into them, while at the same time not neglecting the uniqueness of the EPPO. And I think that's as far as I can go, but again, I leave also the floor to Anna if she wants to say something on that.
I think I'm just disclosing all the admonitions that we are supposed to discuss during the next panel already. But indeed, the Commission has already adopted the first report on EU DPR very recently in October. And in this report, the Commission takes a rather clear view that, following the amendment of EU DPR itself to make it complete, it will also, as a second step, try to unify, will unify and aim to better harmonization of the data protection of operational data also for EPPO. So this is the position of the Commission. The point is that, of course, the idea was to actually tag along this second change. So in this case, the change to the EPPO for data protection framework, with the full respect to the uniqueness of that framework, because it does not preclude that some specific lex specialis will be retained in the EPPO regulation if needed. But to tag along those changes together with the bigger operational revision of the EPPO, which we know might be coming.
Thank you. We had a question. Yeah, please.
Thank you very much. Good afternoon, everyone. It's not really a question. It's rather a comment and a reaction to what was said. My name is Pauline Dubarry. I work at the French Permanent Representation. Just to react at the beginning, because I was one of the negotiators of the EPPO regulation and notably of the data protection chapter together with Juraj and other people in the room. And I'm surprised Juraj wants to go through that again. Just to say that indeed, no, it was just a joke. Indeed, this chapter was negotiated rather at the end of the whole EPPO negotiation, which was very long. And indeed, we could all foresee the end of the negotiation, and we're quite impatient at that time. But I can ensure that a lot of attention was paid to these negotiations under the Dutch presidency in particular. And we did work a lot on these provisions. I'm not sure I would be able to reply to any questions you might have on right now on why such provision is in there, because it was quite a long time ago now. But I can say that we did pay a lot of attention, including to this data protection chapter when we negotiated the text. I just also wanted to react on and thank you for mentioning the call that was made yesterday, but also during the last JHA Council from the French and German justice ministers regarding the possible extension of the competences of the EPPO to the violation of sanctions. I think it's very important that we distinguish this call to the further reflections that were on other possible extensions. I think this one is very specific, very different, linked to the situation. Obviously, we all know in Ukraine and regarding Russia. And I think indeed, this was not foreseeable a few months ago and a few years ago when we worked on the PIV directive and the EPPO regulation. And obviously, this call is linked to this new situation no one had really anticipated. Just to say that we perfectly understand and we hear the reaction saying that this is going too fast and the EPPO is quite new and needs some time to prove and to work efficiently before we envisage its extension, such extension. However, just to mention that we all know and we are all aware, well, at least I guess in France and Germany, that when we launch such a call, it doesn't mean that such extension will ever happen in 6 months or 1 year. We all know that the procedure is long. There are several procedural steps. So we believe that if we want to foresee such extension in a few years, the call and the political impulse has to come now. So this is also why we consider it's a good thing to launch it now. Thank you very much.
Thank you for this intervention. I don't see any more questions from... here, one.
Sorry. Is a question, is kind of a comment as well, is because the presentation, as you said, we have two regimes, but you are investigating and prosecuting in the countries according to the national law, which means I would say it's not two, it's 24 regimes in reality. Considering also that that in some countries, at least, even the way you manage the data during the investigation and then the proper prosecution can create then a revision, a judicial revision, which can include elements of the data, so complicating more the supervision authority. Becomes like specific judicial authorities that have also end up having an impact on the data as well, protection basically. From one side, for the other side, that for me also links to the question about the revision and the harmonization. I work in another EU organizations, not only in the Parliament, and the thing is, often there is a tendency to see we are EU, so EU EDPR applies, the GDPR never applies. In reality, there are cases where both may apply for certain different situations. Now, the thing is, the EPPO has a very specific situation due to this fact of applying, to obeying this context with the 24 regime applying. So it seems quite difficult to make one rule that fit all of them, as in for the EPPO, all allows to have one rule that can cover the EU institution organizations and can cover also EPPO with all this having to comply with this 23 plus the EU one. So I'm not sure that will not create a big complication for you in terms of the process if it's actually practically possible in a reasonable amount of time, unless you have all the work before done, in which all the countries kind of agree on uniforming certain rules, but because you're talking about, again, investigation and prosecution of criminal cases, is something that needs a modification of the treaties, basically, because you go in the territory of the national of the states. So I'm not sure you think you could be able to do that kind of an informatization, covering also without the risk of getting in this conflict with the part where the member states have the authority, effectively.
That's a very difficult question. I mean, I think that already now the EPPO, as was said by Vanessa, is built inherently upon a combination of national and EU law. So any amendment of the EPPO regulation would follow the same path. The only thing I would say, I don't think this requires an amendment of the treaty. I mean, that's the golden rule for the EPPO. Everything is regulated by the EPPO regulation. What is not regulated by the EPPO regulation is regulated by national law. This will continue to be the case. Of course, we will need to see the implications for that, but in principle, I don't see any specific difficulties related to these issues you're mentioning compared to other amendments of the EPPO regulation, precisely because in its uniqueness, that's the rule of the EPPO. But I will let you know in a few years then. Thank you.
Thank you, Fabio. And perhaps one quick question online. Do we have any questions? So not to ignore the online audience.
Yes, actually, we have two, and maybe with a bit of luck we can tackle both. One is about the practical application of Article 80, Paragraph 2 of the EPPO regulation. Just to clarify, this is the situation when EPPO can transfer the personal data urgently to prevent urgent and serious threat to public security. I don't know whether this has happened in practice so far, not to my awareness. But yeah, this would probably require someone from the operational part of the EPPO to answer, unless Stephen has some experience on it. But yeah, that's one the question. And the other question was more directed, I guess, to the Commission, asking for an indication of the first planned amendment either to the EPPO regulation or the EU DPR that would impact, so to say, the data protection regime of the EPPO?
Yeah, just very quickly, I'm looking at Article 8.2. I don't see there, but from the EPPO regulations provisions on the exceptional exchange of operational personal data, it ties in nicely with one more comment I will, because on the unification aspect, our transfers of operational personal data run primarily and so far almost exclusively through the exceptional provisions of the European delegated prosecutors being allowed to use the national infrastructure. And this to me is absolutely crucial, because if we go into the previous colleague's question as well about the various different rules on the national level, to me, the big concern, but that leads then into multiple questions of interpretation of 1725, is that 1725 in general tends to be interpreted in light of those subject to it, which is Europol, Olaf, and the rest of the colleagues to whom it may apply. It is absolutely crucial for us to be close to the member state's interpretation, which would mean that a situation where a member state is allowed to do something which is compliant in national law, and the EPPO would not be allowed to do that because 1725 has a different historic interpretation when it was applied to Europol, that would be the biggest fear I would have, and also on a practical level a problem.
Can I kindly ask to repeat the question? So was it whether the Commission plans to amend first the EPPO regulation or the timing for that? The timing for okay, so the timing for the EPPO regulation, for the revision of the EPPO regulation has not been set yet. So the regulation, as I said, as ultimate deadline provides that by the 1st of June 2026, the Commission should evaluate the implementation of the EPPO regulation and the efficiency of the EPPO, and if appropriate, it might propose an amendment of the EPPO regulation. That said, of course, we can also propose an amendment before if we have enough information that would justify such a proposal for an amended regulation. And so far, we have some information coming from the EPPO, which flagged some issues that do not allow the EPPO to work properly. So we are assessing them, but there is, at the moment, no clear timeline for the revision of the EPPO regulation. Thank you.
Thank you, Fabio. With this, we have reached and overreached, I would say, the end of this panel. I would like to invite you for a big round of applause for our panelists. And as a reward for all of us, lunch is served now at the 5th floor. So please join us. Thank you.
So good afternoon, welcome back for this third and last panel. So last but not least, obviously, we're going to talk about effective enforcement in a patchy landscape. And in order to introduce the topic, we have the keynote from Thomas Zerdik, who is the head of the Supervision and Enforcement Unit at the EDPS, so the unit in charge of supervising EPPO and Eurojust.
Thank you very much, Fanny, and good afternoon, ladies and gentlemen. Welcome back to session 3. Having discussed the recent developments at Eurojust and the EPPO, let us indeed now turn to the supervision and enforcement aspects of those union bodies. As you will see in a few minutes, we'd like to discuss the legal landscape in which the EDPS and the European Data Protection Board have to carry out their tasks, the opportunities and challenges that we face in our daily work, and as well as the possible limits to our supervisory efforts. As the European Data Protection Supervisor Wojciech Wiewiórowski this morning already mentioned, we will also have to reflect together on how to ensure effective enforcement of data subject rights. So let me begin by saying a few words about the EDPS work in this particular area. In the year 2021, the sector of the area of freedom, security, and justice was created, which is a dedicated sector within the supervision and enforcement unit of the EDPS. This newly created sector monitors the processing operations of personal data linked to the core activities of the agencies and bodies such as Eurojust and the EPPO. We want to make sure that Regulation 2018-1725, the EU DPR, and the specific applicable data protection provisions are interpreted consistently and enforced consistently. So with this new organization in the Supervision and Enforcement Unit, the EDPS was able to tackle in a sort of transversal and coherent way topics that affect several AFSJ agencies and bodies. For example, the establishment of new cooperation instruments between Europol, Eurojust, and the UK post-Brexit. The sector also continues to work closely, obviously, with the other sectors in the unit, but also the other units in the EDPS, in particular the Technology and Privacy Unit, which provides the technology and technical expertise required for the supervision. For example, our teams worked together for the audit of Eurojust in 2021 and the operational visit to the EPPO in 2022. So I think while the EDPS continues to deliver here, let me be clear that our supervisory work is far from being straightforward. So let me mention briefly three main factors that influence our actions and our supervisory work. First of all, we still have a fragmented legal framework. The EU DPR introduced a specific chapter on the processing of operational personal data, mostly modeled after the Law Enforcement Directive. This was indeed welcomed by the EDPS as it creates a baseline applicable to all EU eyes that process operational personal data. However, the exclusion at the time of Europol and the EPPO from the scope of that regulation, combined with the continued existence of specific and almost self-standing provisions in the Eurojust regulation, have so far limited the applicability of the provisions of that Chapter 9. The recent alignment of the Europol regulation and the integration into the EU DPR will likely change that situation. But in practice, so far the EDPS has rarely applied any of those provisions in Chapter 9 in our consultations, audits, investigations, or complaints. Now, our task as supervisory authority is to make the protection of personal data as a fundamental right visible in practice in all processing situations. As a consequence, the data protection rules and the EDPS's powers should be uniform and aligned wherever possible. A fragmented legislative framework only undermines the possibility of achieving a consistent approach to protecting individuals' personal data in the EU. This is why we in the Supervision and Enforcement Unit, we follow what we had announced in the EDPS strategy 2020 to 2024. We interpret the applicable rules in the spirit of the EU DPR, and we will apply the principles of the regulation in areas where specific rules are missing. However, legally and obviously, we have to recognize the differences between the EUIs where there are such differences, in particular when specific provisions supersede the harmonized provisions in practice, and that of course makes the goal of ensuring a consistent approach much more challenging in practice. But anyway, I'm delighted that you have the opportunity today to discuss with us the Commission's first report on the application of the EU DPR, to which, I might add, the EDPS contributed comprehensively. And in that context, the EDPS welcomes very much the announcement of the Commission to consider amending the EPPO and Eurojust regulation in a future revision to ensure the full application of the rules on processing operational personal data in the amended EU DPR. This in particular because only that will lead to harmonizing the EDPS's powers over those bodies and agencies and make it coherent with the powers we already have towards the other EUIs. Second point, we have progressing of digitalization and interconnections. And you are aware that we have successive legislative reforms fostering EU agencies and bodies to increase their cooperation and, of course, to increase their exchanges of personal data. And this is only going to be much more in the coming year, specifically when we talk about the so-called interoperability framework. And wherever you have interoperable databases, that means more and more EUIs will have extended access, for example, in the field of law enforcement, to this interoperability framework. So the volumes and the types of personal data and of operational personal data are expanding. The processing operations to be supervised will multiply, and we are not quite clear yet as to which magnitude, but we're working on that. So it becomes much more challenging for the EDPS to follow and to then actually exercise our supervisory functions with the human resources at hand. My third point is on the need for coordination, because that is another supervisory challenge. How do we ensure a close cooperation with the national supervisory authorities? Why do we have to do this in the first place? Because EU agencies and bodies process personal data obtained from national authorities, and the functioning of those EU bodies often needs to take the national specificity into account. So in order for our supervision to be effective, when the EU and national levels are so intertwined, we need to supervise jointly both sides. So I believe we should turn those challenges into an opportunity. The opportunity to work more closely together with national supervisory authorities to help to deliver a hand-in-glove, joint and effective supervision to the benefits of data subjects. That's why the EDPS strongly advocates that the still fragmented legal framework, together with the interconnection of systems, we need to adopt a holistic approach to the supervision of agencies and bodies dealing with law enforcement and criminal justice. To that end, the EDPS already actively participates in various coordinated supervision bodies, in particular the Cooperation Supervision Committee that is established within the European Data Protection Board and which addresses, amongst others, issues related to the supervision of EPPO and Eurojust. We also take part in the supervision coordinated groups of the EU large-scale IT systems processing operational personal data, such as the SIS. So, with this short introduction to the topic of supervision and enforcement, I leave the floor to my colleague Fanny Couder, the EDPS head of sector for the area of freedom, justice and security, who will moderate the next session. Thank you very much, and over to you.
Thank you, Thomas, for introducing the challenges ahead. So after two panels that presented the challenges from the point of view of the agencies, we'll now look at this framework from the point of view of supervision. We'll touch upon the question of, as it's been introduced by Thomas, of how to ensure an effective implementation of the rules in such a complex environment with different stakeholders at national and EU level, different law applicable to different parts of the processing, and different supervisory authority involved. And so to further explore this topic, we have the chance to have with us three distinguished speakers. So first, Clara Guérin, who is the coordinator of the Coordinated Supervision Committee that work in the framework of the EDPB and is tasked with the coordinated supervision of Eurojust and EPPO. She's also a member of the EDPB's expert group BTLE, so Borders, Travel and Law Enforcement. She's a senior consultant of the Portuguese DPA, where she works since 1997. And at national level, she's following cross-border cases and she keeps working the area of law enforcement, where she has a long experience. Next to her, we have Anna Moschidova, sorry for the pronunciation, who works in the field of personal data protection for the European Commission, Eurojust. Since 2020, Anna is a team leader, heading a team dealing with data protection in law enforcement, focusing on transposition and application of the Data Protection Law Enforcement Directive. And before, she was focusing mostly on data protection aspect of migration policies. And she also participated in several Schengen evaluation of the member state. And finally, we have with us Juhai Seifert, who is now a doctoral candidate at the VUB and the University of Luxembourg. He carries out a joint research project in the Netherlands, Belgium, and Luxembourg, called Making Transparent Invisible Surveillance, Digital Investigatory Measures in Benelux and their compatibility with EU data protection law. Previously spent more than 5 years working for the data protection unit of Eurojust at the European Commission, and he has been closely involved in the process of drafting and negotiating the new EU data protection legislation, as we heard previously, particularly focusing on the Law Enforcement Directive, the EU DPR, and data protection rule for EPPO and Eurojust. So let me turn to the first question. So no PowerPoint presentation for this panel. We'll try to do well, the first challenge, at least for an effective supervision. I would like to have the views of the panelists on is about the need to ensure a continuous and consistent supervision throughout the personal data life cycle. So with this expression, I refer to the time span between the moment the data is collected about an individual, usually by a national authority, and then processed by this authority, shared with an EUR, an agency such as Eurojust or EPPO, shared again, maybe again with another agency, so for instance Europol, sent back to another national authority in a raw format or enriched by additional information, and then finally deleted. So that's the personal data life cycle. So in such complex ecosystem with so many authorities and applicable legal framework, how do we achieve the goal of supervising the whole data flow while avoiding, on the one hand, inconsistencies in the way how the data protection framework is applied, and on the other hand, gaps in accountability? Let me turn then to Anna first. As one building block to ensure both consistency and continuity in the supervision is to have a uniform data protection framework, which we have mentioned in the morning already. This is meant to be achieved at national level by the transposition of the Law Enforcement Directive, and at EU level by the horizontal application of Chapter 9 of the EDPR. And the Commission just released 2 reports on the implementation of this instrument. Could you tell us where we stand with this objective of harmonization?
Yes, good afternoon, and thank you very much for invitation for today's event. Yes, so I will go and try to present to you the findings of the most recent and the first report on the functioning and applications of the Law Enforcement Directive that the Commission has published in July this year. That report deals with the number of issues. It also deals with the issue of the transposition. And in that aspect, it focuses on number of the issues that the Commission considered to be priority. So it's not super comprehensive. It zooms into the certain topics regarding the transposition.
Again, those topics are quite a few, so maybe I will just try to present to you what I think is particularly relevant from the point of view of a supervision. So the topics that I think are dealing with, for instance, the powers, the structural problems behind the supervision. Well, the first overall conclusion that the report presents is that the member states have largely completed the transposition of the directive, with one exception, because we have one case pending, one infringement case pending against Germany right now, where the one piece of legislation at the federal level is still missing. Otherwise, member states have adopted the legislation aiming to transpose the directive. So that's on the completeness. On the compliance of those provisions with the requirements of the law enforcement directive, the Commission, the report finds that the member states to large extent do implement the requirements of the directive. However, there are a number of issues. There are some issues that we have identified along the way. So on the topics that interest us in particular, I think I would just right now maybe start with the powers of the data protection authorities. So with respect to the powers, it's on a positive note that the member states, and the vast majority of the member states, do implement the powers of the DPAs, both the investigatory powers and the corrective powers of the DPAs are implemented. With respect to investigatory powers, we were also quite happy to see that the member states sometimes go even beyond the requirements of the directive and are more specific, or granting more specific, more granular extra powers on top of what the LED requires. So that's on the good side. We also see that the member states, the vast majority of the member states, do implement the corrective powers of the Data Protection Authority, and this is done in large number of cases quite faithfully. So the member states would largely repeat the provisions of the LED with that respect, just making that operational. Some member states provide a more general language. That general language, however, allows those authorities to basically execute and exercise all the powers as mentioned under the LED. So the warning, but also the request to delete, blocking of the processing, and so on. So that with that respect, we also again have sort of one exception. So one member states where this has not been done, where we see the certain powers or the number of the powers from the law enforcement directive have not actually been transposed, and the Commission has already started infringement proceedings against that particular member states for lack of effective powers of the Data Protection Authority. So, what we, however, also see is that there are member states who have not implemented the powers of the DPA to go to the court, to go to the judicial authorities and initiate the judicial proceedings or otherwise participate in the judicial proceeding. That we see in few member states that this is lacking. The next point, which I think is quite important, is also the DPAs themselves and resources of those DPAs. So that is maybe not coming so much from the transposition of the directive, but we also looked into the application and the functioning of the directive and gathered the feedback from the DPAs themselves. And what we see is that actually most of the DPAs consider their resources to not be sufficient to undertake all the tasks related to the supervision in that particular sector. 16 DPAs found that these resources are insufficient and hamper their ability to follow on the complaints or conduct audits or investigations on their own will, or even issuing the opinions.
What we however also see is that the DPA themselves seem to largely prioritize their work relating to GDPR and allocate very few staff members to the sectors dealing with the law enforcement. And the very few, the report is actually indicating that it's between 1% and 7% of the overall staff that goes to sectors of those data protection authority dealing with the law enforcement things. In a way, we also see that, for instance, EDPP, although I think it's doing quite a number of important documents relating to the lead, however, there is also much less of interpretative guidance that EDPP issues with relations to the law enforcement directive, and definitely much less comparing with the GDPR. So that's the resources. Yes, and indeed, I think that overall conclusions from the report is that the LAD has actually delivered. So it's a first instrument which provides the comprehensive framework and the complete framework relating to the protection of personal data, and its applications actually produced a good effect, in particular with relations to much bigger awareness with regards to the data subject rights. There is quite an important increase in the access request and related complaints, which indicates that this is sort of uptaking. There is much more also awareness on the part of the competent authorities. So this is a very good sign. We see we have reported on definite improvement regarding the security of the processing. That's something that member states themselves quite praise. So overall, the conclusions are that the LED have delivered, and it is right now a little bit too early to consider the revision of the LED. So the more time is needed to see how that instrument will function, and more interpretative guidance is also needed in relation to that instrument. So this is a big sort of request to EDPB to uptake on this, and we have in the report indicated some of the points that would be particularly relevant in our opinion for the EDPB to look at, like for instance the functioning of the consent in the context of the law enforcement. Or, I mean, right now we know that EDPB is also looking on the issue of the transfers, and we very much encourage that work. I will stop here and happy to contribute on other issues later.
Thank you, Anna. I will now, as you have sketched quite with some quite detail the powers of the DPAs, I will turn to Clara as chair of the Coordinated Supervision Committee, and I would like to ask you how the work of DPAs in the context of the CSC is contributing to avoid these gaps in accountability in such complex ecosystem to supervise.
Thank you, Fanny. Good afternoon. Thank you for the invitation, first of all. As to your question, well, first of all, the CSC, the Coordinated Supervision Committee, is ensuring or tries its target, its aim to ensure an horizontal approach that never happened before in terms of supervision. We also have several groups, fragmented, and it's important that the supervision also follows the interactions of data flows between the systems, because what we have now is a variety of several EU information systems, with some more coming, some in the pipeline to be set up. And we'll have a couple of dozen maybe over a dozen systems, and with access privilege from one agency to some system. So it's a cross path of everybody almost exceeding everybody else's systems. So we need to reflect this as well in the supervision scheme to be able to follow these interactions. And of course, supervision to be effective, we need to be able to cope with these data flows. As to your question, indeed, it's difficult. The supervision, it's a challenge. It's difficult, of course, because each system has its own legal framework, so like the fragmentation that we were talking about, then complemented by the LED, which was transposed in different ways in the member states. Okay, there is a certain level of harmonization, and of course here I would like to remind that before the LED, most of the member states did not have any data protection in the law enforcement area. So this is for many member states, for the controllers, as well as for the DPAs, it's a kind of a new experience. So the CSC is a forum where we can all take advantage of being together and of taking advantage of the experience of some of the member states and some of the DPAs who already have these, for many years, they indeed supervise law enforcement. On the other hand, the Coordinated Supervision Committee allows an holistic view to carry out its supervisory authorities across the systems. This is important to follow the interactions, to supervise. And if you go to the EDPB website, a little advertising, if you go to the EDPB website and you go to the CSC page, you can see the activity, the working plan for the next 2 years, where it is already envisaged one activity that goes from the Schengen Information System, which is a little bit delayed to come to the CSC preview, but now newly scheduled for March, and Europol, for instance, to explore what will be a new kind of alert, information alerts, which are advised to member states by Europol. So it would be, we are going to try to see the both parts in the Schengen Information System and in Europol. So this is just an example that we are almost already taking this step to make these supervisory activities across systems. On the other hand, this kind of centralization of supervisory authorities brings also more dynamic between the national level and the European level. And indeed, our work in the CSC has been reinforcing the relation between the EDPS and the national DPAs, because we are trying to use as much as possible the exchange of information to feed the supervisory activities. It's right, the EDPS has its findings in the central systems. The central systems are fed by the national authorities. In some cases, then the information goes back after being analytical and with more input goes back to the member states. The information is sent according to national level, to national legislation. So it's very important that even if some issues are detected at central level, then the national DPAs can investigate at national level and see indeed if the information should have been sent to the Eurojust, EPPO, or EPPO is a bit different indeed, or Europol, or not. So indeed, that's what we are trying to do, also to find new ways of reinforcing this and coordinating this supervision. It doesn't mean that we all do exactly the same thing, because coordinating does not necessarily mean that 27 are doing the same things at the same time, because some phenomena affects more member states than others. So we can have parallel actions according to member states' reality. Of course, responsibility, also the lawfulness and the data quality of the data we send to the central systems are key at national level. But just to finalize, I would say that this higher engagement between national DPAs and EDPS and this general overview that this model allows benefit supervision. For us, also, it is important. We can use without prejudice to any academic debate, which is always necessary and has its own merits. But we think also that through supervision, we can help detecting and exposing and show where the shortcomings are, where the problems are raised with this fragmented legislation, and in that way also demonstrate why things have to be changed. And I think that we'll have some more reportings on this. It's one of our ambitions to be able to show where the problems are, and we hope then to address this to the Council and to the Commission and also to the Parliament and to the public in general, so we can indeed more than avoid the gaps. I think that we will detect the gaps and then we'll find common solution to fill in the gaps. Thank you.
Thank you, Clara, also for highlighting this very important role of a supervisory authority of making things visible, actually. I will now go into explore a second challenge, which is the limits of data protection authorities in the field of criminal justice linked to the material scope of competence of these authorities. On the one hand, DPS are not competent to supervise court when acting in their judicial capacity. It's under the GDPR, the LED, or the EU DPR. And on the other hand, there seems to have some conflicts as well in terms of material scope between data protection and criminal laws at national level. And Juraj, I will turn to you. As academic, you have looked in details into these two issues. So could you introduce us to these obstacles that DPA may face when trying to enforce data protection provision in the field of criminal justice?
Well, thank you, Fanny, and thanks for inviting me. It's a pleasure to be here. It's a big week for data protection in law enforcement because there is this conference today, there is the CSC meeting tomorrow, and then there is the final conference of my research project on Thursday and Friday in Luxembourg. So really cannot be better week than this one. I just wanted to say, well, this is not what I wanted to start with, but now that you mentioned these three limitations on how courts cannot be supervised when acting in their judicial capacity, I was reading the other day the framework decision 2008-977, the legendary predecessor of the LED, and I couldn't find this particular limitation. That was very interesting for me. But be it as it may, and be it as it may as well, what Clara said, that this sort of data protection for law enforcement is new for a number of member states. On the other hand, this sort of administrative data protection supervision of the law enforcement authorities is, on the other hand, annoying the law enforcement authorities for a while now, because it already, the Convention 108 and its protocols and amendments required some sort of administrative supervision, and it was applicable across the board. So it is there in a way for a while, but we still have concerns about its effectiveness for reasons that were mentioned before and for some other that I will mention. So then you had also Directive 9546 establishing supervisory authorities in EU member states, establishing the Article 29 Working Party, and then in some member states you had often extension of the application of Directive 9546 to at least some law enforcement authorities, like especially police. So there was that already, and there was the supervision, as I said, through the framework decision 2008 for sure, the obligation to have administrative supervision through the framework decision without this limitation. So that's what exists for a while now. Historically, on the other hand, there were also different supervision models for in particular for judicial authorities or almost independent judicial authorities. Why I say almost, because that we will discuss later. And so the authorities that we are looking at with a specific focus today, like Eurojust or the European Public Prosecutor's Office, are particularly relevant in this discussion because Eurojust had the joint supervisory body as a supervisor, and that was not administrative supervision. That was inspection or supervision by judges. Right? I even remember I was once speaking with a member of the Eurojust joint supervisory body. I will not say his name or his member state affiliation, but he told me like, oh, I don't want some bureaucratic institution like EDPS to supervise Eurojust. You know, it should be supervised by judges, not by some bureaucrats in Brussels. So this is this has to also be taken into account that there is this, or there was at least this sort of reluctance to submitting certain authorities that are more judicial authorities than anything else to administrative data protection supervision. And then, of course, the turning point in all this discussion is 2009, when the Charter of Fundamental Rights becomes binding with the Treaty of Lisbon, because it not only lays down a specific right to protection of personal data in Article 8, but it also, a part of that right is Article 8, Paragraph 3. So compliance with data protection rules must be controlled by an independent authority. So there is this obligation now embedded in primary law ever since. And the question is then, in this particular context, what is this independent authority that will actually supervise? I think that the data protection supervisory authority, so this administrative supervision, is particularly relevant in the context of judicial authorities or prosecutorial authorities, because I perceive administrative supervision as a fundamental right defender in the digital age. I would just again, from a historical point of view, highlight the role of the DPAs that they had with the indirect access, for example, in the context of the Schengen Information System, and where they were basically a proxy for the data subject, and that was a fundamental shift away from the traditional legal system in which the activities of any public authority could be scrutinized only by judges. So, and that system we still have in the LED as a fallback provision. I think it's very important, Article 17 of the LED, indirect exercise of data subject rights, because if a police authority refuses to your access request, then the supervisory authority can access the personal data of a data subject stored in police databases and make sure that the personal data is correct, that is processed lawfully. So that is a historical role that is very, very important of the administrative supervisory authorities. From the second point that I would like to make is that of course, the EU insists on the independent judiciary, obviously, but it also insists, and that we have a lot of case law from the Luxembourg Court, on the complete independence of these administrative supervisory authorities. And the question that is mainly the main question I would like to highlight here is how to reconcile these two requirements in a criminal justice system. And I think that's much easier for police than for prosecutors or criminal court judges, and that's obviously relevant for EPPO and Eurojust. Vanessa already highlighted Article 45 of the LED and the two types of tensions that it creates, because supervisory authorities can supervise police and criminal justice authorities processing personal data for the purposes of the directive on the territory of their respective member state, but they are not allowed to supervise all the activities of the those authorities, because when courts are acting in their judicial capacity, the supervisory authorities will not be allowed to supervise them. And in addition, the LED allows member states to exempt other independent judicial authorities when acting in their judicial capacity. So, of course, if you look at the EU CJU case law and how under EU law this notion of other independent judicial authorities should be interpreted, I think the answer is that it should be interpreted very restrictively, because there is case law that will show you that a lot of these other independent judicial authorities, in particular prosecutors, will not qualify as independent. So we have a lot of case law on that. The latest one is, the famous one is Procurator, because that was also about data retention, but there's some case law before that. And a lot of prosecutors will not be deemed under EU law as independent to be qualified for this exemption. But that doesn't mean that the factual situation on the ground in member state will fully respect this notion, and that some prosecutors who should not be independent will actually benefit from not being supervised by the administrative data protection authorities, and which is especially relevant for the EPPO, because the EPPO is supervised by the EDPS. So we have to see how this all works together, right? In the context of the EPPO and Eurojust, as I said, the administrative supervision of the EDPS was eventually accepted, but there you can see that there was some reluctance because there were also some limits. If you look at the Eurojust regulation or the EPPO regulation, you will see that the supervision is weakened compared to the powers of that EDPS normally has over other EU institutions and bodies under Chapter 6 of Regulation 1725. So what we have to answer is what is the actual meaning of certain qualifiers that we have either in Chapter 9 of Regulation 1725 or in specific legal acts. Now I will quote, for example, Article 41.2 of the Eurojust regulation says that EDPS needs to take into utmost account the secrecy of judicial inquiries and criminal proceedings. Or Article 40, paragraph 3 says that EDPS, in the exercise of its powers, needs to take into account the implications for investigations and prosecutions in the member states. So what does that actually, how does that limit or reduce the powers of the EDPS? Or Article 85, paragraph 3, litera E of the EPPO regulation, which is on the most important ones or hard ones, corrective powers of the EDPS, where the EDPS can order rectification, erasure, or restriction of personal data, provided that this does not interfere with investigations and prosecutions led by the EPPO. So what does that mean as well? So that is, I think, very relevant for us today. And just the last word, because my time is up. I had a lot of other things I would like to say, but I just wanted to say also about the LED corrective powers in Article 47 that Anna and Clara mentioned already. Even if they were transposed correctly, these provisions are very weak. They have a number of qualifiers, like such as, for example, you could maybe have those corrective powers, but if you don't, question is what happens, are they effective, are they not effective? This is also something that needs to be assessed in a lot of detail, and I'm glad that there is an infringement case about this. So maybe we will know more about this as well, but it's also very relevant in this context to understand what are the actually effective powers, especially corrective powers of the DPAs under the LED, and that's why it's a pity that the EDPB never adopted the guidelines in Article 47 LED. Thank you.
Thank you, Juraj, for this great introduction to the topic. I will now turn to Clara and ask you maybe to share with us the point of view of data protection authorities on this specific issue, in particular as regards the scope of competence of DPAs. I understand that EDPB has commissioned a study on the concept of judicial authorities acting in their judicial capacities. Could you tell us which were the conclusions, a bit more about the study, please?
Okay, yes, of course. Well, this is indeed an issue. GDPB commissioned a study that was issued in the summer of 2020. Well, the very main conclusions is that the study confirms that there are different interpretations and national implementations of GDPR and LED in this regard. Because of the lack of guidance of the legal text, or the legal text in GDPR and LED, forced the countries to create solutions themselves, and result is the absence of harmonization. This is the main findings. Nevertheless, the study identified a clear trend in 18 countries out of the 27 plus the 3 from the European Economic Area that have a functional interpretation of what judicial capacity means. Is that to say, as a further specification, so to be, we may say, interpreted restrictively. But now that you mentioned something about how should we interpret other independent judicial authorities. This study also provides some interpretation on that, which is a restrictive interpretation, does not include prosecutors in these authorities. And you are quite right. There are most recent case law on saying that prosecutors are a part in the proceeding, so they are not independent. But give other examples like other kind of arbitration courts or some courts that are set up for temporary for certain issues. So it's equivalent in their way of working as and the role as courts, but for specific things. So this was in the main conclusion of this study. Of course, that according to the study was led by Professor Custers from the Leiden University. Okay. And accompanied with 3 authors. They think that they consider that the wording of the LED favors dysfunctional interpretation. However, this wording only comes in recitals, not in the articles themselves. So what poses additional challenges? From the DPA's perspective in general, and of course I cannot speak on behalf of all DPAs, we have not discussed this as a group, okay, but from my own perspective, we think, of course, judicial authorities are subject to supervision and to independent supervision. And this is important because it was identified that in some member states, there was, it was not the DPA supervising, it was another body, but that body was the Ministry of Justice, for instance. It happened. So, of course, this is against the Charter, Article 8.3, paragraph 3 of the Charter, that requires an independent supervision. From the DPA's point of view, I would say that, of course, we need to work with the text, with the legal text that we have. So which is also free for interpretation, and we have to have a narrow interpretation of what judicial capacity to what is strictly necessary and connected to the proceedings and to the decision making. In other words, where the independence of the courts and of the judge have to be guaranteed, because that's the rationality of this derogation. This is a derogation, indeed, it's a derogation to the general system, so to the general regime. So it means that as a derogation, it should be always restrictively applied, and to what is necessary and proportionate. So what is here to safeguard the independence of the judges, and we all agree with that is necessary. It comes with the checks and balance. But so it should be only excluded what is really necessary for the decision making. I don't know. I can give you the example of my own country, where we have data protection since '94 with the DPA, and our data protection law, which was prior to the transposition of the Data Protection Directive, was always equally applicable to law enforcement and judiciary, always, from the beginning, with only 2 derogations to the right to information and to the right of access. So we are the example that we had one single instrument for all private and sector, law enforcement, judiciary, everything with no problems until GDPR and LED came. So until then we had no problems. And indeed, one of our, because it comes with also our constitutional order, the fundamental rights of the individuals, including the right to data protection, within a judicial proceeding is safeguarded by the judge. So, of course, we never handle a case where the access to data was, when people came to us, we said, you have to go to the judge to exercise your rights. You have the same rights as well, but you have to exercise towards the judge, not towards the DPA. And we always supervise the information systems of the judiciary. It has a lot of security problems, access rights, all that comes with data protection, and does not influence whatsoever the decision-making and to guarantee the independence of the judges. And we were always able to do this with no problem whatsoever with the judges and the magistrature and all those, for us, sometimes it looks like monsters, sacred monsters that we respect, but we always have this good understanding. We never overstep because it's also the procedural and constitutional order, and you have to abide by it, but they were always supervised. So it's possible to be done. That's what I'd like to say. Thank you.
Thank you, Clara, for illustrating that this is actually possible and not a problem when applied in practice. So with that, I'd like to turn to the third key issue for effective enforcement data protection rule in the field of criminal justice, which is how to ensure the effective enforcement of data subject rights. You have kind of introduced the topic in such patchy environment. So from the EDPS perspective, I must say that it's quite an uncharted territory because we haven't received yet any complaint against Eurojust or EPPO. National authority have started, however, to receive and it's to complain in that field. That's what transpired, for instance, from the Commission report on the implementation of the LED. So, Anna, could you tell us more about it? Also, understand, do you have identified some other issues, such as, for example, the lack of transposition of the provision allowing NGOs to file complaints on behalf of individuals?
Yes. So maybe actually starting from again, I will try to be very brief this time, on the transposition. So with regard to transposition, what we saw is that all member states have decided to transpose the restrictions to data subject rights. So all provide for the restrictions of the rights of access. I mean, just a reminder for those who do not know, there is no such obligation for the member states to introduce the restrictions to the data subject rights. And nearly all member states provided for other restrictions. So there are a few member states which only have the restrictions of access, which is in itself, I think, an interesting point to note. And then how those restrictions are, provisions on restrictions are transposed, what we see is that at times member states sort of repeat the provisions of the LED, which means that those provisions are very general, and then the question is whether actually there is a national legislation, the sectorial legislations, as we would say, that makes those restrictions concrete, operational, and the frame in what circumstances exactly do you restrict the right, what type of analysis you do, and what are the conditions, and so on. So without this sectorial legislation, well, I mean, for us there would be a question mark regarding those transpositions. So this is on the transposition data subject rights, and then again, yes, we go and see how the redress has been transposed, and indeed we see that in quite some member states, the Article 55 of the LED, which provides for the data subject going to the civil society, the non-profit organization, and asking for help initiating the access request and the complaints, has actually not been transposed, which is also a notable point. On Article 17 that Juraj have mentioned, it has been transposed nearly, well, in all member states it has been transposed. Now the question is how and to what extent this is actually done correctly. I think it's important to know that Article 17 is right now, let's say, as Juraj explained, the fallback position. So the data subject has a possibility to go directly to the competent authority, so to the police, to judicial authority. Again, a very notable point, LED applies to courts and judicial authorities. The exception relates to the supervision, but not to the application of the rules. So data subject has to have a possibility to go directly. When his rights are restricted, he shall also be provided with possibility to go indirectly via a data protection authority. In which case, a data protection authority is actually doing verification of the lawfulness of the processing of the data subject rights. I'm emphasizing it because then the question is, it's not the complaint route. It's not the complaint. It's actual verification. So this is interesting. And now, as you probably know, we do have a court. There is a preliminary ruling coming actually from Belgium on whether or not the Belgian has correctly transposed Article 17 and, generally speaking, the way of exercising the data subject rights. It would appear that the Belgian has not provided for the possibility to go directly, but only via the DPA. And then the question is, to what extent this is allowed, yes or no, and what it actually means also for the questions of judicial redress, because that's, of course, once you refuse as a data subject, you can go to DPA, you can initiate complaint to the DPA, it's another possibility, but you could also go to the court and try to enforce your rights in front of the courts. So this is it. I think one point that I will maybe very briefly mention is that the Thomas and Juraj, they both mentioned the EU DPR and the idea that we also need to have a consistent framework there. We have discussed it already in the previous panel a little bit, but indeed, the Commission has taken a look, has issued a report on EU DPR, and then what maybe has not been said clearly before. So one thing is to bring the EPPO under the roof of the EU DPR. Yeah. So right now we've managed to do that for Europol with the recent amendments. Eurojust was already under. Now it's time to bring the EPPO. So that's one of the conclusions. But the second conclusion is that yes, we have this EU DPR. Chapter 9, the special chapter, as Thomas explained, that applies to the law enforcement activities of those of the agencies. But now, I mean, we just have to make sure that this house, this common roof, is a complete one. So the idea is to actually change the EU DPR, to open to make a very targeted amendment in EU DPR that will ensure that EU DPR as a whole is applicable. That would include the powers of EDPS. And Chapter 9 would be a specific chapter that would, to some extent, regulate certain things in a specific way. So in a way, there would be a lex specialis comparing to the remainder of the EU DPR. So that's the idea, and we came to the conclusion that allows the largest possible consistency and harmonization across the fields. It also allows to bringing in a new law enforcement agency under that common roof without much extra work and developing the specific frameworks and so on and so forth. Would also be important in terms of the Frontex, because Frontex right now also have small, however, small, not small, but I mean, it has a targeted, let's say, I should say, whatever say, nevertheless, the law enforcement powers. Yes, I'll stop here.
Thank you, Anna, for this intervention, for explaining us the gaps. We'll turn now to Juraj. Maybe you didn't have time previously to talk too much about the interplay between data protection and criminal law. So my question would be about what do you think could be the impact? Clara touched upon giving this example of what happening under Portuguese law. Would this interplay could have an impact on the efficiency actually of the right of the data subject?
Thank you, Fanny. Yeah, the clock is there now, I see. Okay. Yeah, I mean, definitely. I hope this part of my intervention is not too academic, but I think that definitely there is a lack of conversation between data protection law for law enforcement, criminal procedural law, and even human rights law to some extent. So I think it seems to me that there is a lot of these things are looked into silos, and then a lot of practical problems occur from the lack of that conversation. And I just highlight some examples that are relevant, especially in the context of this conference, and then or the EU law that we are discussing right now. For example, look at Article 5, Paragraph 3 of the EPPO regulation that Fabio mentioned before, saying basically whatever is not regulated in the EPPO regulation is regulated by by national criminal procedural law. So national criminal procedural law applies to everything that is not regulated by the EPPO regulation. And in the context of when criminal procedural law tends to be very detailed about certain things, especially about data collection, and data protection law is often considered or perceived or even written in a way that is more general, more abstract. The question is, of course, what does that actually mean in practice, and does it mean that the criminal procedural law somehow trumps or prevails over data protection law? And in that context of EPPO, even more difficult conversation because it's a national criminal procedural law versus EU data protection regime, right? Or another similar example is Article 18 of the LED, which is super misinterpreted quite often in member states. So first of all, Article 18 is in Chapter 3. It's only about Chapter 3. It's only about data subject rights. And it basically says that, as is the case in some member states, like, for example, like in Germany, that if you have data subject rights in the context of data protection for law enforcement, you are allowed to embed them in the national criminal procedural law. You don't have to have a separate data protection law for law enforcement with data subject rights. But often the case is that actually there is either in the academic debate or even in the practical transposition of the directive in some member states that you find provisions saying that basically this article means that national criminal procedural law prevails over the national law transposing the LED, which is completely incorrect, super wrong, way blown out of proportion. I don't know how to emphasize more how wrong is that, right? So that is I think the problem. On the ground level, what is actually the practical usage, meaning, and application of data protection law in the context of criminal proceedings on side by side with national criminal procedural law? And here I'll give you another example, which is from a recent that I shared already with the panelists, which is from the recent judgment of the Dutch District Court from 2021. I can give the reference to anyone who is interested in the context of EncroChat investigations, right? And just to say that when it says Police Data Act, the court means the national law in the Netherlands transposing the LED. So the court says well, it has not been argued nor has it become plausible that with respect to the encroached data, the Police Data Act has been violated. Okay. Furthermore, the court is of the opinion that even if this were the case, the Police Data Act is not an important regulation of criminal procedure. Assessing whether the provisions of the Police Data Act have been complied with is therefore not a question that the district court needs to answer in the context of nor is it a question that needs to be answered when assessing whether there is a fair trial violation or not, as referred to in Article 6 of the European Convention on Human Rights. So that's what I see as a problem. There is a regulatory disconnect, in my view, in this regulation, and in particular when it comes to digital investigative powers of law enforcement authorities. So in particular in the current context that we are living in, because it seems to me like the collection of data is regulated quite extensively in criminal procedural law, so like gathering evidence, but then data analysis not so much. I feel like the data analysis, so matching, combining, whatever, big data, AI, whatever, is left for regulation of the data protection law, which is less detailed or more abstract than the criminal procedural law is, and then that creates certain disconnect, basically what I said, and this in particular doesn't make sense from the data protection point of view, because in the data protection law, data processing is everything, right? We don't make a distinction between data collection and data analysis and data transfers. This is all data processing. So sharing data, everything is regulated in the same way or same type of regulation from the data protection point of view, and I don't see that in criminal procedural law. And then when I mentioned the human rights law, also in this context, because I feel that it is quite apparent from both national and European case law that whether or not privacy and data protection fundamental rights have been violated in the context of criminal investigations and criminal proceedings seems to be, as the example that I've shown, not such a big factor on whether the right to a fair trial in criminal proceedings has been violated or not. And I feel that, especially again in the context of digital investigations and data analysis, the way that this has been done today, I feel that there needs to be more automatism, or at least more consideration of the fact that the mere violation of Article 8, be it in the ECHR or CFR, can lead, at least in some cases, automatically to a violation of what my friends from Strasbourg would call automatic violation of Article 6, the right to a fair trial, right? And as long as this is not the case, there is a disconnect there as well. And as long as this is not the case, there will be more of this type of conclusions, such as the one I found in this particular Dutch case law, but I'm not blaming Netherlands. This is just an example that I found, where simply the criminal courts will find, yeah, we have these data protection rules, these LED transposition rules, but is this really a big deal? Is this important in the overall context of criminal proceedings? And so that is basically my major concern, and that is where I would like to have much more both exploration on the academic level and practical studies, empirical studies on a practical level, and much more dialogue between those branches of law in order to create some impact, especially for the data protection law in the context of law enforcement and criminal proceedings.
Thank you, Juraj. I think this shows that we really need to dig deeper. That's one of the challenges in this area, into the interplay between data protection and criminal justice area and criminal law. And that I anticipate, I can only anticipate that during the supervision of EPPO, Eurojust, or national authority, DPAs may be confronted with such a key question about how they can reinforce each other rather than suppressing one over the other. Thank you very much. Finally, Clara, could you sketch what are the challenges linked to enforcement of data subject right in these cross-border cases? Because that's what we're talking about.
Well, I think that the enforcement of data subjects' rights is the challenge that we have, because in this field of criminal justice, for many reasons. First of all, the data processing in this field is much less transparent than in other domains. Data subjects don't even realize sometimes when things are wrong. They can be in a vulnerable position to exercise their rights, or they don't know how to do it. In that field, the Coordinated Supervision Committee will assist. We are developing guides to help data subjects to navigate with all these several systems with different rules, similar but different. Secondly, because we are talking about the exercise of rights, which by the nature of this field are usually subject to restrictions, to a legal regime of restrictions, and of course there are many possibilities available in the law, and I would say there is a general practice and culture, and from the culture comes the practice of secrecy and refusal. So it's off bounds. Usually it's the organizations, the first reaction is no access at all, and of course that we can have restrictions. They have to be substantiated. They have to be duly justified in every single case, but the rights cannot be abolished. The right of access is a fundamental right in itself. It's instrumental to the right of correction or to the right of deletion if in case there is unlawful processing. I just would like to refer to the preliminary ruling, the Belgium, because there is something that Anna didn't mention, but for me, I think it's key. Because the Article 17 of the directive says that the data, I'm quoting from memory, that the Data Protection Authority would have to check to verify if everything is lawful, and at least, this is very important, at least inform of the verifications that proceeded to verification. It means that it's the minimum that the DPA may inform the data subject. It doesn't mean that it's the only thing. That's how the Belgian law provides. Maybe other laws, I don't know. And this is the game changer, because it's completely different to say at least, or to say it's the only thing that the DPA shall inform. Because we had some experience with indirect access to the rights. And of course, that if it was justified and there were no restrictions that the DPA could inform the data subject, the DPA shall inform the data subject, because if the right was unduly restricted, it's up to the DPA to provide the information that was wrongly denied to the data subject. So I'm waiting to see what the court will decide on this issue, because I think that it's really very important. So, but I think that this is an area where we don't get many complaints. You just have, because this is less transparent. People do not know. You have complaints when more informed citizens, of course. But I think that here also the DPAs can also should make regular inspections just to check how the exercise of rights are being granted. In the absence of complaints, because I don't envisage that there are a lot of complaints on this, even Article 17, let's see. But I think that we can check and verify, and it's a way to go. And organizations, of course, should have written internal procedures. In what concerns Eurojust and EPPO, it's indeed a challenge, because we have a network of consultations, objections, providers of the information, plus member states concerned. So everybody can, one of these elements of this complete great network of consultancies, if one objects, then okay, there is a decision, but we know that the decision is most motivated for one objection may lead to a decision of refusal. So let's see. I think that this is a matter for not only guidance on how to exercise, but also a matter for the CSE in a coordinated manner with EDPS and national DPAs to further development, and at least to establish fast procedures for ourselves when we have to intervene, because we would have to intervene as national DPAs and EDPS. So this is a kind of a second phase after the guides on how to exercise the rights. This is a good way to go. We did it for Schengen many years ago, similar thing, but now it's more complex. To have to use this cooperation platform to have fastened procedure among ourselves to handle these kind of cases, of complaint cases on. But I think that indeed I think that it's really it's a key aspect of the data protection regime, and it's one of the most difficult to address, I think, in practice, to have good results. But we have to try, and to try to start doing that in a more holistic way as well. So we'll hope that this way we can also tackle this issue. I think this is really a quite important issue, and some current cases or actual recent cases show that data can be very wrongly processed and lawfully processed. And if the data subject is unable to access the data and to react, even in the courts, go to the courts to react to this, it's the end of the world. It's the end of the rule of law, because this is really key. This is the very, very important. That's why it's a fundamental right in itself. So I think that it's one of the challenges with all this patchy landscape. But I think that we also have to talk with each other and try to make some sense out of this. Thank you.
Thank you, Clara, also for mentioning this need for DPAs to work together to set up platform to be agile in the handling of complaints, because we didn't receive complaints against Eurojust and EPPO, but we have all the complaints where we had to cooperate with national DPAs, and this lends to very, very lengthy investigations because of back and forth, and I think that's a really key issue in order to ensure the protection of data subjects in such a key task of a DPA. So we'll close at least our discussion between ourselves on this very important note. I would like to open the floor to the audience in case there is any question. We have 10 minutes, so please. Yes.
Thank you very much for the interesting discussion. And you touched upon certain issues that I didn't get the chance to present earlier on. My question would be regarding Article 18 of the Law Enforcement Directive. As I've been working on this article myself, and I agree with you, I said this is an article that is massively misinterpreted. I read in the report of the Commission that all member states, or nearly all member states, have used Article 18 to refer to national procedural law for the exercise of data subject rights. having made an attempt myself to dig further and see where this leads to, very often it seems to be a near dead end because it refers to national criminal procedure, and then you have to dig into national criminal procedure to know. Again, from my own member state, I know that national criminal procedure, even though there's a referral, does not respect data subject rights. So I was wondering whether Article 18 will be in the center of the attention of the Commission and perhaps also the CSC for its further work, because I think this is really, this is where digital, where everything that's digital, but also data protection and criminal justice interact. I have the feeling that Article 18 has really been exploited by member states to get around the law enforcement directive, and so I was wondering whether this will be at the heart of your future work, because I think if one key article, there are many, Article 45 is another one, but I think this is one of the key articles that merits further investigation. So are you planning, one of you?
Yes, so as the Commission's report on the lead is identifying the data subject right as an area of priority. So, and then we look at everything that relates to the data subject right. So Article 18, in a way, it is included in that priority area. Yes, so that the question, the simple reply, yes, we will look into it. I mean, I'm not making a decision, but the idea is to continue with the infringements with relating to the member states on the issue that we identify. On the Article 18, yes, it is true that most of the member states simply refer back to the criminal procedure. As such, the fact that they refer to criminal procedure is not a problem. Yes, then the problem is whether this criminal procedure is actually doing what it's supposed to be doing in order to allow data subjects to exercise these rights, which is, of course, extremely difficult legal assessment. And well, we will see how far we manage with that. But just also, let's say, that would be my view that yes, I mean, it's not the Article 18 does not allow member states to say, I have my old criminal procedure from like 60 years ago, and therefore it's fine. In my opinion, member states should actually read this procedure and see, okay, to what extent it complies, it allows the exercise of the data subject rights. I assume that in many cases for certain data subject it will. It might be that there are some data subject, in particular those that are not necessarily the party of criminal proceedings, there might be a bigger problem. And then we will have to see where we go with this.
Well, we will address only in the extent that when we are, because we are not dealing with the lead directly. We are dealing with the European information systems with their own rules, and only when they interact with the lead, if in the extent that we will handle it if we recognize any problems in coordinating our actions. If we come along, at least we will analyze or make interpretation or give guidance, all that are within our legal tasks. Yes, if we jump into it, if it comes to us, not if we jump, but if it comes to us.
Maybe we can take another question.
Look at Article 49, paragraph 6 of the EPPO regulation, because there you have your list.
So we have two questions from the floor, from Diana and then from Kazimierz.
Well, if you allow me, I wanted to share two comments from my personal experience in this field. One is linked to something that Wojtek said this morning about specificity of dealing with judges and prosecutors and the type of persons they are and how they think and work. And I think there is a weakness in the system linked to the fact that at national level, I don't think it is given enough attention to data protection in the education of judges and prosecutors. And I see, at least from my experience, and I said this is a personal comment, of working quite some years at Eurojust, a big difference between the level of knowledge and understandings depending in the different member states. Some people come in with a very good knowledge, and some others look at me with big eyes and big surprise when I start talking about data protection, while they have a long experience at national level. So I think that's something in which data protection authorities are not all as maybe committed as the Portuguese one is in the judicial field, and some others might need to invest more in raising awareness. The second comment is more linked to the implementation of the LED, and there I also see a weakness of the system is the fact that all the existing international agreements that existed at national level remain valid. And of course, it's very good for the free flows of data with all those countries. But from the data protection viewpoint, I see that while we at Eurojust have very high standards and invest a lot of time and energy in assessing transfers and doing case work, case by case and all that, at national level, everything is possible and simple because all these agreements remain in place. So I think this is an area in which some work could be done at EU level. Also, having more adequacy decisions based on the LED could be a key element. I think after all these years, having only one is, from my viewpoint, I would say a very poor result. I know the reasons, but still, I think this is something that could help to increase a higher level of data protection in that area. Thank you very much.
Thank you, Fanny. I would reverse the first question asked to the panelists and asked maybe a bit provocatively, because we are talking about this interplay between both philosophies in a way of data protection and criminal law, which I think, as Juraj said, merits very detailed reflections as we go on. And I think you're rightly saying that, you know, for people from the criminal justice, they tend to think everything is fine, everything is already there, why do we need data protection? Whereas for people in the data protection community, we tend to think, no, you have nothing, you need to apply fully our fancy data protection. So to ask a bit provocatively, are there institutions of the criminal procedural law, in your view, that achieve certain objectives of data protection, data subject rights? Anna hinted to that a bit, right? That maybe if you are a defendant, you have access to case files, so maybe it's okay to a certain extent. How would you define, you know, the scope within which criminal law actually does deliver a little bit what data protection wants, and to what extent it cannot deliver it, and data protection needs to be very strictly kind of implemented into the national law? Maybe Juraj, I would be the most curious to hear your views on that, if okay. Maybe Anna as well.
Well, let me just first make a comment about what Diana said. I think it's probably due to this unfortunate grandfather clause in Article 61 of the LED. Even though I think that one means basically that there is a legal basis for transfers, but doesn't mean necessarily because those other old agreements were grandfathered. So there is a legal basis for transfer still, but I'm not, even if they're grandfathered, I'm not sure that means that the requirements from Chapter 5 of the LED are still not to be looked at or applicable. So that's something to be looked into, even though I know how in practice that this happens at the member state level. When it comes to the question from Kajik, I think that the answer to your question lies in different examples from different member states and how they are reforming their criminal procedural laws. And there you cannot really expect or have any sort of harmonization. And so I can only say that there are very good examples, like for example, I already mentioned Germany. I think it's Article 101 of the Criminal Procedural Code of German National Criminal Procedural Code, if I'm not federal, I mean, if I'm not mistaken, which actually provides detailed data subject rights in the context of criminal proceedings, in particular context of certain digital investigative measures that could be undertaken under by the German criminal justice system. So if you have those tailor-made data subject rights rules over there, I don't see how this could be detrimental. I would say it's beneficial for data subjects, and in the context of more, let's say, more general rules that you have in the LED or national laws transposing LED, I think that's only complementary, helpful, beneficial, and it works together probably to the extent that even more than I would expect good for the data, in a beneficial way for data subjects. But on the other hand, I think the problem is that I was referring to, which I find extremely problematic, is these other two scenarios, which are unfortunately more frequent, which is either that you have the sort of renvoi to the National Criminal Procedural Law, which is meaningless because the National Criminal Procedural Law does not meet the criteria that are laid down, at least in Chapter 3 of the LED, which for me is a incorrect transposition of the LED, so subject to infringement, obviously, proceedings automatically. Or even worse, the example that I mentioned, which comes from Sweden, where Article 18 OLED was transposed in a way that it says, basically, it says that the national law says that the National Criminal Procedural Law prevails over data protection law. So that is even a worse example, because the National Criminal Procedural Law, not only that it prevails, but also doesn't have any sort of data subject rights, even the minimum ones that you would expect that you would have to have according to the LED. So yeah, to put it short, I think there is a disparity of answers, and it depends on the national interplay, and this really cannot be harmonized, I think. Yeah.
Thank you. No, okay. So we're going to we reach the end of the session, of the panel. I think we can. Do you want to maybe add something or not? Yeah, sorry. And after that, we close the session.
Yes, I mean, I largely agree with you, Rai. So obviously the criminal law, if there would be a reference to it under Article 18, has to meet the standards of the LED. And what that exactly means is, as I said, I think extremely complicated, but again, I agree it would basically require case-by-case assessment analysis of those laws and comparing it with the requirements of the LED, and also looking how that actually looks in practice. I believe that. But I do believe that, I mean, in principle, it is possible. So I would say that the criminal procedure, especially at the level of the courts procedure, the criminal courts, those instruments that are already there, access to file, they are there as a kind of expression of I mean, they have a different purpose, but they also allow the full access of the parties to their own data. So yeah, I mean, just to give another example, to make things a little bit more complicated, now we were talking only about the access to file, yes, but we can also have a discussion about a deletion of the information from the judicial files. And again, case-by-case assessment, we would have to look how that national provisions regarding the corrections or deletions from the criminal files play off with the standards of the LED. But I think my message is that I don't exclude that they are actually fine.
Clara, you want to say a few words?
No, I just would like to thank you again, and to extend my happy birthday to Vaida, because she's a former colleague and Diana mentioned her, and I was almost forgetting. Happy birthday, Vaida.
So happy birthday, Vaida, as well on our behalf. Yeah. I would like to thank the panelists for such an interesting discussion, for raising such an interesting topic. I think we have a lot of work ahead, but that's a very nice way to close this conference before the closing remark by our director. I would like to introduce.
Yes, ladies and gentlemen, colleagues, after a full day with 3 sessions, sadly you realize all good things must come to an end. But as every great conference, and I believe this is one of those, we have one more thing for you, our closing remarks. I'm pleased to give the floor to Leonardo Cervera Navas, the director of the EDPS. Leo, the floor is yours.
Thank you very much, Thomas. Good afternoon, dear colleagues. I am perfectly aware that I am the last man standing before the promised drinks, so I will be extremely brief in my presentation, although my colleagues have given me some messages to pass, and it's my job to pass you a few messages. Those of you who were with us in the June conference, you probably heard me saying that I was very honored to speak to la crème de la crème of the data protection experts in Brussels and in the EU bubble. Today, I am very honored to speak before the la crème de la crème of the experts on data protection in the public sector and more particularly in the criminal justice sector. I think the discussions we have had today have shown the level of the event, and I must confess that when we, together with the Wojciech's cabinet, we were reviewing the results of the conference in June, we felt that there was much more to say on enforcement of privacy rules in the public sector. We think that the enforcement of EU's data protection framework should not remain limited to private sector and big tech companies. The number of European agencies and bodies is growing, their competences are expanding, and so the volumes of personal data they process. I can confirm that this remains a top priority for the supervisor and for the Secretariat of EU officials I am so proud to head. Eurojust will soon change considerably. New types of data, secure communication channels, new case management system, and finally, new tools for information exchange for the joint investigative teams. Even if all the reforms discussed today do not substantially change the data protection provisions of Eurojust regulation, they will have a huge impact on the way Eurojust is processing operational personal data. This, in turn, will influence the EDPS monitoring and supervising actions. While we see the added value of digitization in the area of criminal justice, we shouldn't shy away from the new challenges this digitization brings. We have already touched upon some of them today, but there is certainly much more to discuss. For instance, digital case files open up new possibilities for the use of advanced AI tools. Possible use cases for such tools at Eurojust or EPPO could easily fill the agenda of yet another event. We all wish for legislation with detailed ex-ante assessment of its interferences with fundamental rights, including privacy. However, there are situations like the Russian aggression on Ukraine where the EU needs to act swiftly and decisively. We support the efforts of Eurojust to coordinate member states' investigation into war crimes committed in this terrible conflict. At the EDPS, we will do our utmost to help with implementing the new mandate in full respect of the applicable data protection rules. This goes for relations with non-EU partners too. While we are proud of the EU's high data protection standards, we need to continue a mature reflection on the role on their role, the role of these high data protection standards in our relations with partners from outside of the EU. In the absence of adequacy decisions based on the Law Enforcement Directive or international agreements providing for appropriate safeguards, the assessment of the transfers is left to the specific controllers, EU agencies and bodies. This is not an easy task, especially in the area of criminal justice, where there is a strong public interest in administering justice. I think we all agree that using derogations for transfers is not meant to be the rule. An exception cannot be the rule. And therefore, derogations should not allow for frequent, massive, and structural transfers of personal data or large-scale transfers of data. The EPPO seems to have much more flexibility in this regard, as it can rely on member states' agreements concluded prior to the Law Enforcement Directive and the EU DPR. In theory, all EU bodies share a similar framework for international transfers of personal data and should follow the same standards. In practice, in the real world, it seems that the same information may or may not be transferred outside the EU, depending on who intends to transfer the data and on what legal base. Being the first EU independent investigative and prosecutorial body, the EPPO pioneers in many areas. While a single European body certainly fosters investigations and the cross-border exchange of information, its unique nature should not become a disadvantage for individuals and should not weaken the effectiveness of the rights and remedies when it comes to processing of their data. We will continue the constructive dialogue with Eurojust and EPPO and the excellent cooperation with their great DPOs. However, EDPS dialogue with both institutions is only part of our role, meaning that we will not hesitate to exercise our powers when this is considered necessary. I also look forward with hope to our cooperation with national data protection authorities in the supervision of Eurojust and EPPO, especially in the case of the latter, where operational level is strongly embedded in national structures and rules. This cooperation is crucial. Today's discussions have shown that the Coordinated Supervision Committee has rightly selected data subjects' rights as the key area of study activity. The EDPS stands ready to raise awareness and provide guidance to assist individuals in navigating the great number of different rules when exercising their rights. I am confident that we will reach a common understanding on the respective scope of supervision and the areas where coordination and joint actions are needed. After today's conference, there are many ideas to be explored, and this is precisely what we have done today. We have used the old community method by which we have sit together, we have fostered cooperation, dialogue, respect, and we have seek balanced outcomes. So the legitimate needs pursued by the criminal justice sector is perfectly balanced with the legitimate needs of the data protection experts. I must confess that when I am here in Borchette, I become a little bit nostalgic. Some of you colleagues will probably share the same thing. I can see Stefano Rodota and Giovanni Buttarelli sitting over there, or Peter Hustings and Diana Alonso over there, or when the accession came, new Eastern countries, Wojciech started to show up. So I think in this particular field, we are starting new things, and I think this conference today probably will be kind of historical because we are setting the path for a very interesting developments in this field. So I also welcome wholeheartedly the intention expressed by the Commission and contained in the report of the EU DPR application to clarify the relation of the law enforcement chapter to the other provisions of that regulation. This is extremely important. We are also happy that this report opens a discussion on the further extension of the EU DPR to EPPO. To avoid fragmentation and interpretational differences, specific data protection rules should exist only where necessary. A uniform and clear legal framework will greatly help to the supervisory authorities of the EDPS. So now let me just thank all the speakers for their presentations, remarks, suggestions, those here and those in the cyberspace. Without your participation, the success of this conference will not be possible. And also many, many thanks to the EDPS colleagues who have worked so hard for so long to make this possible. It looks like easy, but you cannot imagine the amount of work this entails also in the technical level. So thank you so much, colleagues, for making this possible. So we have made possible a European dialogue today. I think we have succeeded, but following the principle of accountability, we are going to send you a survey that I kindly ask you, please, to complete.